I need to mention item number 28. Today we will file our affidavit of opposition on behalf of the government GST.
28.
28.
Okay, who is for a petitioner? Okay, Mr. S.K. Saha. Right, counsel for the petitioner is present. Dr. B.N. Gauhati, standing counsel CGST, has submitted that counter affidavit on behalf of the respondent CGST authorities is going to be filed, the counter affidavit, during the course of the day. Post of in the event the post of the release the case after 3 weeks. The petitioner may file its affidavit in reply. In the meantime, if so advised. Any interim order?
Yes.
The interim order, if any, past idea shall continue till the next date of listing.
Develop.
My lord, I beg to mention, my lord, for listing of a motion item in the production list, my lord. My lord, interfaith religion, my lord, marriage has been solemnized. Now, my lord, police is severely harassing the entire family, my lord. My lord.
Friday.
My lord, can it be tomorrow, my lord? Some urgency is there, my lord. If my lordship,
Tomorrow is a problem. Okay.
my lord,
Tomorrow.
and two,
Tomorrow.
my lord, two eviction matters on Friday, my lord. Not praying for tomorrow. My lord, oblige me.
May it please your lordship. Your lordship, with regard to item number 50, lordship. Here in this matter, we have filed an idea and copies has already been served, lordship, as the matter was
Not listed.
not listed, lordship.
Then what can I
Praying
do?
for calling to take with the record,
No.
lordship.
Lordship, in item number 50,
Item-
Lordship on Monday had given a date today
Today,
for
lordship.
lifting of an IA. They have filed the IA yesterday.
Yes,
So
lordship.
we pray that that IA be tagged along with this matter and be taken up today. And
Okay.
I am for the petitioner side. I am praying that I filed my objection. That may also be requisite.
You have filed your objection.
I
Yes,
filed
Lordship.
my objection to their IA.
Okay.
Allow us to record, tag with it. Deeply
If
obliged.
time permits. If
Along,
time permits.
along with item number 50, Lordship.
Only if time permits.
Yes.
Lordship. deeply
Obliged.
obliged.
May I please, your lordship. Lordship, I appear for listing a matter regarding correction of land record, your lordship, in admission column.
Give it to the court.
May I please your lordship? Lordship, with regards to item number 33, lordship, we have filed an IA yesterday for implement of the PWD department, your lordship. However, the same is not tagged with the record. Lordship, may I kindly adjourn the matter for the day?
Okay, Miss
J. Sharma.
J. Sharma, Learned Counsel for the petitioners, submitted that the petitioners have filed an interlocutory application seeking implement of a necessary party, and the said interlocutory application has not been listed. So, Ms. Sharma has therefore submitted that this matter be adjourned for listing after weeks with the interlocutory applications from already filed. First off, it is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. First off, list the case after a week.
Obliged, lordship.
May I please, your lordship? Lordship, I beg for listing of a writ petition, your lordship. It's an eviction matter, your lordship. Can it
Motion.
for motion, your lordship? It's a notice has not been issued, your lordship.
Monday.
Maybe on Friday, your lordship.
Monday.
Lordship, there is some urgency, your lordship. Lordship,
Friday.
obliged, your lordship.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 25, lordship. Lordship, the council has some difficulty today. Lordship may take it up some any other day, lordship.
Okay, you have mentioned earlier. Mention memo.
Lordship, yes, I have.
Okay,
circled
you
the-
are Mr.
A. Goswami on behalf of the Forest Department, lordship.
Okay. Mr. A. Goswami, Learned Counsel on behalf of the respondent Forest Department authorities have submitted that as you want adjournment
Lordship, yes.
has sought for and is granted. How much time?
Your lordship.
How much time?
In lordship, 2 weeks time, lordship.
2 weeks time to file counter affidavit.
Lordship.
Post of yes. A mention memo to that effect has already been circulated yesterday.
Your Lordship, I'm for the petitioner. Kindly fix a date, Your Lordship.
Miss
ADAS.
Ada Aslan, counsel for the petition is present. Raise the case on so and so.
16 September, 1609.
Lordship, obliged.
Supplementary item number 53. Can I pray that the matter be taken up after the end of the motions, my lord?
We normally don't
I
allow.
I know, my lord. If my lord.
We do not allow.
My lord.
Yeah, please, Your Lordship. Your Lordship, I beg to mention on read petition for listing, Lordship. In motion column, Lordship.
What is the subject matter?
Your Lordship, inter-religion land dispute, Lordship. The matter is related.
No
to-
urgency. It will come within the normal course. Yes.
Daily list for motion, item 1.
Please, Your Lordship, we have been intimated that the inquiry has already started and the order has been in the process of compliance, Lordship.
So you are not pressing.
Not Mr. Lordship.
Mr. A. Kakoti,
Kakut.
learned counsel for the petition has submitted that the petition is not pressing this contempt petition in view of this, in view of subsequent developments, the petitioner is not pressing this contempt petition. In view of the above submission made by Mr. Kakoti, learned counsel for the petitioner, the contempt petition is closed. As
Leave
not
your
pressed.
Item 2.
Please, Your Lordship. Lordship, I'm before this court on with a very limited prayer, my lord. My lord,
Limited prayer I have heard.
my lord, once
On many occasions I have heard.
one
No
small
more
request.
hearing.
Just one small request, my lord. My lord, my secured assets have already been auctioned.
You have remedy elsewhere.
My lord, my only remedy is facilitation, my lord. I only seek the auction records from the bank, my lord. Nothing more than
You
that.
filed RTA.
My lord, I filed a representation at page 70.
Yes.
Yes, Lordship, we are supposed to file some.
We are not RTA forum.
My lord, if they may dispose of my representation at page 75.
Your Lordship,
RTC active.
page number 1 is the 13-2 notice. And page number 3 is the 13-4 notice. With photographs and all. And thereafter we have made a request under section 14 and the affidavit is at page number 16.
Which is the rule?
It is section 14, your Lordship.
Section 14 is one that is for that affidavit.
Yes, in the section,
And regarding publication and all,
it is 13-4,
13.4.
section 13-4.
And which is the concerned rule?
Rule is 8-6.
8.6.
Eight one, your Lordship.
Any auction?
Yes, auction has been done, your lords. But I'm only seeking my lord's indulgence to provide me the auction records, my lord. That's my only prayer.
Go before that.
My lord, I had filed representations at
can-
page 75, my lord.
DRT can decide all the issues.
All the issues here. Why you are coming here, Mister?
How-
I have facilitated. I wanted to get the information. It should have been dismissed in limine.
My lord, this is 50% of the documents that they have provided me. If I get the auction records, I
No,
can,
Mister, show me. Where is the scope for in a petition?
my lord,
Show us 226.
my lord,
From a
17
long line of authorities, right from Mardia
my lord, my
Chemicals.
only humble submission is,
We are still trying to give you the, we tried to find
my
out
lord, may
whether,
kindly extend my lord's benevolence by.
we are
giving me the
not,
auction
we have,
records.
how many times we have tried to,
Well, they have already
facilitated
furnished
you.
50% of the documents, remaining 50% if they
is
provide.
it a RTA forum, mister? Is it an RTA forum? Is it an RTA forum? Tell me.
Then my lord may at least direct them to dispose of my representation at page 75, which I have already addressed to the bank.
File, which section?
75, my lord, page 75.
13.4, your lordship was on the.
No, remedy?
Remedy is under section 17 of the
But-
Surface Act.
My lord, there is a difference between commission and omission, my lord. Section 17, I can only invoke. if they-
Hesitate all the grounds before the forum which has been set up for agitating
But,
all
my lord, I do
issues.
not have the
We are not
materials, my
here.
lord. I don't have the materials. What should I plead? On what ground should I challenge, my lord, if I don't have the documents only, which I have
Mister,
requested?
you are
them to
Mister
provide me?
Raskua,
P. Handic, my lord.
handy.
My lord, your
Shall I
benevolence.
diverse all this now? Your conduct,
My lord, my only,
shall I reflect in the order?
leave it to my lord.
Shall I reflect? Your conduct all throughout your period. You have lost FIRs also, right?
No, no,
Huh?
I have not lost FIRs.
Good.
I have only filed a representation seeking the auction details, my lord, at page 75.
Which auction detail? It is in the public domain.
This,
Madam, it's
your
not
lordship, paper
uploaded, madam.
publication has
Huh?
been made, your lordship.
Huh?
And besides that, service has also been effected.
Is
Everything
it not in the public domain?
No,
Auction
my lord,
notice?
the valuation report, the final
It is-
bids.
Is it a forum for valuation? Please show us an authority that this is a forum. The read code is a forum to obtain valuation report, medium.
My lord,
Tell me, satisfy me that this is the forum that everybody should run to the High Court to get a valuation report.
my lord, I am only praying, rest I leave it to my lord. I'm only praying that the bank may dispose of my representation at page 75. It is outside rule section 17, my lord. I'm not on merits, my lord. I'm not going into the merits of the case. I'm only seeking that they dispose of my representation.
Let us
at page
see your
75.
representation. This
My
is the last court.
My lord,
This is the last court,
last court, my lord.
right?
I'm only praying for
Last
facilitating.
read court
Last court.
where any read petition is disposed of with a direction to dispose of the representation.
My lord,
Let us come.
page 75.
What is not to be done directly is to be done indirectly. Yes, Mr. Sharma,
Yes, your lordship.
have you not disposed of?
Page 75.
No, your lordship. After that, the writ petition was filed, so it was pending, your lordship.
Amount of auctions accepted by the bank from the successful bidder. You treat this as a application under Right to Information Act. That is all. Yes,
Yes, sir. Well, they may provide and we can dispose of the writ petition.
we do not.
Well, my limitation is running. That is,
Mr. Handy,
I'll leave it to my lord. Leave it to my lord. Because they have already.
we are not the forum for RTI.
My lord's benevolence is already.
No
granted me
benevolence.
50%.
No,
of the
you
documents.
wrong the wrong forum, Mr. Handy.
These are all the pre-auction documents. I only need the post-auction documents, my lord. My lord may extend my lord's.
This is
benevolence.
RTI. Treat this as an
My
RTI application.
limitation period is running. That's why I approached this
Treat
honorable.
this as
court.
an RTI application.
I filed 3 representations still.
I indicated to Mr. Dihingi already on 3 occasions.
Leave it to my lord.
Right. I extended the benevolence to the maximum possible. But you are still asking for more.
I filed 3 representations till date, my lord. But the
Your
bank.
Lordship, earlier it was the submissions that we have not filed an affidavit connecting to.
See, Mr. You don't make submission in installment.
Well, there was a
Right.
prayer.
When, no,
My lord, I had considered my prayer on the last date.
okay.
Prayer is at page
Mr.
32. P. Handick, my lord.
P. Handy. Learned counsel for the petitioner. Mr. H. K. Hajarika, learned counsel for Junior Government Advocate Assam. For the respondent number, please take your seats. One, two, three, and Mr. M. Sharma, learned counsel for the respondent number 14. First, para. The petitioners, comma, 3 number, comma, have approached together to institute the instant writ petition, seeking to invoke the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India. Full stop. Para. It is stated that the petitioners applied for a housing loan to the respondent Union Bank of India, comma, Jorhat branch, for construction of an Assam type house on a plot of land measuring 1 bigha, 1 katha, 7 lesas, comma, covered by Dag number 992. And Hiras periodic patra number 236, comma, situated at Khatoni Moja. Police station, Jorhat, district, Jorhat, Assam, subject property. Postal. After scrutiny of the application and relevant documents regarding right, title, and possession of the aforementioned plot of land, a housing loan amounting to for an amount of rupees 8,74,250 was sanctioned and disbursed after execution of the necessary loan agreement and deed of mortgage, wherein the petition number 3 was the guarantor. First off, the loan amount was disbursed in 4 installments, WEF 2012-2016. First off, after getting the loan amount of rupees 8,74,250, the petition number 1 and 2 started to repay the loan amount as per the installments decided. First off, however, at the time of COVID-19 pandemic, they defaulted in repayment of the loan installments. And as a result, the loan account was declared as non-performing asset within bracket NPA. First off. According to the petitioner, they received a possession notice suddenly on possession notice dated 27/2022 from the authorized officer that within bracket respond number 5 suddenly. First off, the possession notice was issued in exercise of the powers conferred under section 13 within bracket 4 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Act 2002, read with Rule 8 of the Security Interest within bracket Enforcement Rules, 2002. First off, with the Soko's notice, petitioners and the public were cautioned in general not to deal with the subject land and property. First off, according to the petitioner, the possession notice was issued despite their repeated approach to the respondent borrowing authorities for settlement of the outstanding dues. First off, the petitions have stated that they expressed their bona fide intention to regularize the loan account. First off, the petitioners have further stated that while they were negotiating with a prospective purchaser for sale of their land located elsewhere, the bank issued a sale notice for e-auction of the subject secured assets on 26/10/2022. Why is that sale asset 2022?
Your Lordship, sale notice.
No, notice.
Page
That was
49, my lord.
It is at page
2022.
Yes, Your Lordship.
My lord, after that, there have been negotiations with the bank, my lord. I have annexed that.
No, Your Lordship, we have
We are not here for negotiation, Mr. Henry.
page number 49 is the sale notice.
Page number.
49. They have received the sale notice also.
Where is the date?
Date, your lordship, in the mid of the last paragraph, your lordship, just up of the last paragraph. In page number 49, left hand side below.
Okay. 2016-2022, where is that?
20,
2016-2022. Annexer 3.
Well, at page 40, that was the first sale notice. They revoked it, and then at page 49 is the second sale notice, my lord. Page 40.
it is page number 40, your lordship, the first sale notice.
They revoked this and they came up with page 49.
Initially, comma. From the materials on record, comma, it has emerged that the respondents Union Bank of India as the secured creditor caused a demand notice dated 19/4/2022 under section 13 within bracket 2 of the SARFAESI Act. Cause a demand notice served upon the borrower or petitioners. Petition number 1. Petition number 1 and the petition number 2. Within bracket the borrowers, calling upon them to pay the dues within the time stipulated therein, full stop, as they had failed to comply with the said notice within the period stipulated, comma, the authorized officer had taken possession of the immovable secured asset under section 13 within bracket 4 of the SARFAESI Act, read with rule 8 of the security interest within bracket enforcement rules, comma, 2002, full stop. A possession notice dated 20/07/2022 was thereafter issued by the authorized officer, comma, as per appendix Romans 4 of the security interest within bracket enforcement rules, comma, 2002, and the same was delivered upon the borrowers and was also affixed to the properties mortgaged with a secured creditor, comma, apart from publication of the same in newspapers. Full stop. The borrowers were by the demand notice, the borrowers were informed about their right to redeem the property within the time available under section 13 within bracket 8 of the SARFAESI Act. Full stop. As the borrowers failed to clear the dues of the secured creditor, comma, the immovable secured assets which were taken possession by the authorized officer, comma, was decided to be sold by holding public auction on 18/11/2022 by inviting bids from the public through online mode. Full stop. However, the auction process scheduled on 18/11/2022 was not conducted,
Your lordship, was not materialized For
or
want
did
of
not
bidder.
materialize due to lack of
bidder.
bidders. Full stop. Para. Thereafter, by another notice of 15 days,
Yes, your lordship.
and notice dated 30/11/2022 of 15 days for sale of the immovable secured assets under Rule 8 of the security interest within bracket enforcement rules 2002 was served upon the borrowers, informing them that public e-auction e-auction. Another public e-auction was scheduled on 21/12/2022 by the authorized officer by inviting bids from the public through online modes. Full stop. In the notice dated 10/30/11/2022, the reserve price for the secured, immovable secured assets was fixed at rupees 21,80,000. Which was earlier fixed at rupees 24,22,000 in the notice dated 26/12/2022. Pursuant to the notice dated 30/11/2022, the petitioners, the borrower petitioners, stated to have submitted an application before the branch manager, Union Bank of India, Jorhat branch on 27/12/2022.
Posited 3 lakhs million after that.
Stating inter alia that against the loan account dues, they could not submit the pending dues in due time because of the circumstances beyond their control. Due to hospitalization of the petition number 1, which was a circumstance beyond their control. So it was mentioned that where is the 3 lakh? No mention.
My lord, I have that pleading, my lord, at
Page 57, my lord.
13, you know.
Page 57, my lord.
It is mentioned that a sum of rupees 3 lakh
3 lakhs, my lord.
was deposited by the petitioner borrowers on which date?
26/12/2022, my lord.
26/12/2022. Against
It's the loan amount of 8,46,000.
outstanding loan dues of rupees 8,46,726.07, as on, as per the notice dated 30/11/2020.
After that, my lord, Lok Adalat proceedings took place at page 56, my lord. Annexure 10.
In the meantime, the secured creditor submitted an application before the district magistrate Jorhat under section 14 of the SARFAESI Act. to assist the respondent bank as the secured creditor in taking possession of the secured assets. Post of on the application on the basis of the application, the district magistrate Gauhati passed an order on 12/12/2025. Detailing an officer for maintenance of law and order during taking over physical possession of the secured assets by the secured creditor. It was after taking over physical possession on which date
Your Lordship, it is on 8th of
8th of
July, Your Lordship,
2026, my lord.
2026.
8/7/2026.
That was after my lord passed an order, my lord, which is at page 67. My lord had passed an order before this. Because of that, they could take the bank possession, because then the DM passed the order. Your order is at page 68, my lord. This was an order passed by my lord. Because of my lord's indulgence, they could take the physical possession.
Otherwise, you were resisting.
Otherwise, they were not able to take over, my lord.
Otherwise,
It was
they could
only
not
after
Because of Mr. Hendik, this was an order passed by me,
yes, my lord.
right?
After this, they could take the physical possession.
Okay. 12/12/2025. First of as despite the order dated 12/12/2025. And fixation of a date, fixation of 29/1/2026 as the date of taking over physical possession of the secured assets. The official deputed by the district magistrate Gauhati withdraw the assistance without any reason. The respondent bank as the secured creditor approached this court by preparing a writ petition WPC number 3228/2026. Raising a grievance that there was no compliance of the direction there was no compliance of the direction of the grievance that despite the order dated 12/12/2025, there was no compliance of the direction during the subsequent period for taking over physical possession of secured assets. Full stop. And the repetition was moved, the State Council on 22/6/2026, the State Council asked for some time to obtain instruction as regards the region for withdrawal of the assistance on 29/1/2026, the date scheduled for taking over physical possession of the secured assets in terms of Section 14 of the SARFACI Act. Full stop. Para. It is stated that thereafter on 8/7/2026, the authorized officer with the assistance of the district administration, district magistrate, Gauhati, took over physical possession of the secured assets.
Yes, sir.
Full stop. Para. After such taking over of the physical possession, the petitioners, thus borrowers, submitted a representation on 7/7/2026 seeking settlement of the loan account by repayment of the outstanding dues. Oh no, not. This is earlier. Para. In the above backdrop, this petition is filed, seeking setting aside and quashing of the order dated 12/12/2025, passed by the District Magistrate Jorhat under Section 14 of the SARFACI Act, and for quashing and setting aside of the action of the respondent bank in taking physical possession of the secured assets on 8/7/2026 on the basis of the possession notice, which according to the petitioners was ex specie invalid for not mentioning the date and place of issuance, and for failing to disclose the name and designation of the authorized officer purportedly in violation of the mandatory provisions of the security interest within bracket enforcement rules 2002. Full stop. A direction in the nature of mandamus has also been sought to the respondent bank to restore the possession of the secured assets to the petitioners and not to proceed further with the sale, transfer, alienation, or creation of any third-party interest over the secured asset pursuant to the impugned proceedings. Full stop. A prayer is also made to produce before the court the original records relating the proceedings under Section 13 and Section 14 of the SARFACI Act, including the application under Section 14, affidavit of the authorized officer, valuation report, possession records, possession notice, auction proceedings, and all connected records. It will next prayer. The prayer made regarding those records, aforementioned records, was made earlier by the petitioner borrowers before the authorized officer on 15/7/2026. Full stop. The said prayer is in the nature of information under Section 6 of the Right to Information Act. Full stop. Regarding notwithstanding prayer, notwithstanding the above command is quote on considering, as certain allegations were made regarding non-compliance, this court on uh, uh, as on 27/7/2026, the learned counsel for the petitioner had made a contention that on 8/7/2026, the impugned order had been executed without due compliance of the provisions of the Surface Act, more particularly, section 14 thereof. The learned counsel appearing for the bank was asked to submit as regards due compliance and adherence to due procedure in taking over physical possession of secured assets. Post of. Section 14 of the Surface Act has provided that where the possession of any secured assets is required to be taken by the secured creditor, or if any of the secured assets is required to be sold or transferred by the secured creditor under the provision of the Act, the secured creditor may, for the purpose of taking possession or control of any such secured assets, request, in writing, the district magistrate within whose jurisdiction any such secured assets or other documents relating thereto may be situated or found, to take possession thereof, and the district magistrate shall, on such request being made to him, A, take possession of such asset and documents relating thereto, and B, forward such assets and documents to the secured creditor. Full stop. It has been provided therein that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor declaring the aspects listed as small Roman 1 to small Roman 9. And on receipt of the affidavit from the authorized officer, the district magistrate shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured assets within a period of 30 days from the date of application. Post of the auction 8. It has been settled that taking a possession of the secured assets and documents relating thereto, and to forward the same to the secured creditor by the district magistrate under section 14 is only a ministerial act. Within bracket, NKGSB Cooperative Bank Limited versus Subir Property and others. SCC Silobo. It was safe. Level. The district magistrate is required to satisfy whether the authorized officer had submitted an application with the affidavit satisfying the clauses from clause 1 to clause 9, comma, listed in section 14 of the SARFAESI Act. First, it is settled that the statutory obligation enjoined upon the district magistrate is to immediately move into action after receipt of a written application under section 14 within bracket 1 of the 2000 SARFAESI Act from the secured creditor for that purpose. First of, as soon as such application is received, comma, the district magistrate is expected to pass an order after verification of compliance of all formalities by the secured creditor referred to in the proviso to section 14(1) of the SARFAESI Act, and after being satisfied in that regard, comma, to take possession of the secured assets and documents relating thereto, and to forward the same to the secured creditor at the earliest opportunity. The latter is a ministerial act, and the time is of the essence. And this is the same is that time is the essence, is of essence, is the spirit of the special enactment, comma, SARFAESI Act. Full stop. Para. Rule 8. Has provided for the procedure of sale of immovable secured assets. Full stop. Rule 8 of the Security Interest Enforcement Rules 2012. Full stop. Rule 8(1), right?
Yes, your lord.
A possession notice, comma, referred therein, comma, is required to be published as soon as possible but in no case later than 7 days from the date of taking possession, comma, in 2 leading newspapers, comma, 1 in vernacular language, having sufficient circulation in that locality, comma, by the authorized officer. No, there is another one, is it not?
Your lord.
Rule 6.
Rule 6 is for the movable, your lord.
Okay. It is entirely provided that before effecting sale of the immovable property, comma, the authorized officer shall obtain a valuation of the property from any approved valuer and in consultation with the secured creditor, comma, fix the reserve price of the property and may sell the whole or any part of such immovable secured assets by any of the following methods outlined in A to D. Full stop. Inviting by one of the methods prescribed is public auction through e-auction mode. That notice was served 30 days.
Yes, your lord. They have already annexed with their application also.
The authorized officer is required to serve to the borrower a notice of 30 days for sale of the immovable property. Close stop. Para. The documents, para, placed before this court by Mr. Sharma, learned counsel for the petitioner, are perused. On perusal. Comma, base code finds. Substantial compliance of the provisions of the SRPC Act. Compliance on the part of the authorized officer in making the application under section 14 of the SRPC Act, supported by the affidavit satisfying the conditions laid down in section 14 of the SRPC Act. Full stop. There were due publications of the possession notice in two daily newspapers on 22/7/2000. Huh? What are the new newspapers?
Newspaper is at page number 3 and 4, Your Lordship.
Ah. What is the date?
Date is 22/7/2022. And possession was taken on 20/7/2022.
No, the sale notice. Huh?
The sale notice is at page 49, my lord.
Sale notice is at page number 49 of the.
First of
Well,
para.
the statute says 30 days, they have given you only 15 days. So
No,
there's an anomaly there. my lord.
Subsequent sale, Your Lordship.
Page
If
49.
so far as publication is concerned, full stop. It is settled that in the if the petitioner is aggrieved, petitioners as borrowers are aggrieved by any act, aggrieved by the action of on the part of the secured creditor in taking over possession of the secured assets. They have a remedy of preferring an appeal under section
17 of the. SRPC.
17 of the SRPC Act. Full stop. In an appeal under section 17 of the SRPC Act, all the grounds are open for the petitioners, as borrowers, although are open to be agitated. Full stop. What are the decisions where the petition is not to be entertained?
That Whirlpool is there for alternate remedy.
Oh, Whirlpool does not come here, mister.
Well, section 17, my lord has already asked me to go to the DRT. I only needed the records, my lord, auction records.
I have already held, it is an RTI.
RTI, my lord has disposed it there itself.
Yes, absolutely. We are not to be relegated to the State Public Service Officer, or what is that, SPIO. We are not SPIO. In fact, I was intending to dismiss it with clause, but anyway. Dismissed. Later part I will do. The documents placed by Mr. Sharma is kept with the case record by marking as document D.
Obliged, your lordship.
Item 3.
May I please, your lordship? Lordship, this is a case, lordship, for non-payment of ex gratia amount, lordship.
Ex gratia.
Lordship,
Okay. Due to
due to COVID-19, lordship.
COVID-19. Okay. Yes. Any scheme?
One notification has been annexed, lordship.
Heard Mr.
I mean, lordship.
Ali.
I mean,
Amin. Learned counsel for the petitioners. Mr. S. Dr. Learned Standing Counsel, Revenue and Disaster Management Department for the respondent number 1. 2 also?
1 and 2, yes. Lordship.
1 and 2. Mr. H.K. Hazarika, Learned Junior Government Advocate, Assam for the respondent number 3 and 4. And any health.
Health.
Not shown. Okay. The petitioners are the wife and 2 sons of one late Kamal Das. Post of according to petitions, late Kamal Das died contacting coronavirus COVID-19 on 28/9/2020. First of, it is stated that a late Corona Das contacted COVID-19 while performing duty as chowkidar at Moran Revenue Circle. First of, the petitioners are seeking ex gratia grant as the next of in stroke legal heirs of a government employee who died while discharging duties during COVID-19 pandemic in terms of an office memorandum dated 8/10/2020 of the Revenue and Disaster Management Department from a government of Assam. Issue notice returnable on so and so as top 1 and 2, Hazarika 3 and 4. No formal notice, extra copies. The Land Council for the petitioner shall serve a copy of the writ petition along with annexer within 2 working days from today to the Learned Standing Council, Health and Family Welfare Department, Government of Assam for the purpose of service of notice. For service of notice upon the respondent number 5, the name of Learned Standing Council, Health and Family Welfare Department is to be reflected in the respondent side that call this.
3009. 3009.
The name of Mr. B. Government will be recorded.
Okay. Then H. Purva on behalf of Mr. B. Gogoi, Standing Council, Health and Family Welfare Department for the respondent number 5. Little last total now. Last total থাকিব এই খালি extra copy যেটো যে সার্ভ এইটো লাইন গুছাই দিব
Obliged. Item 4.
May it please, my lord. My lord, as per my instruction from my senior Mr. B. Chaudhary, my lord, what has happened in this matter, my lord, the concerned officer, my lord, who was supposed to give us instructions, he's on a raid operation in Hailakandi district, my lord. Today evening, he'll be arriving in Gauhati, my lord. So, may I pray for listening this matter to
You are not desealing the premises still.
No.
my lord.
Then tell him to come from directly from raid to High Court.
Then timing, my lord. Let Mr. B. Chaudhary appear in this matter, my lord.
Instead of raid, he should come to the High Court then.
My lord. Yes, lord.
5. Item 5.
This will, Mr. Mishra,
My lord, some,
second half,
my lordships.
at the time, other.
My lord, much obliged.
Item 6.
May it please your lordship. Lordship, the petitioner's current bank account has been completely frozen. Lordship, the allegation is of rupees 49 rupees and
Which bank?
18,000.
Which bank?
HDFC Bank, my lord.
Heard Mr. R. Karimlan and counsel for the petitioner. You are for?
I am appearing on behalf of respondent number 4 and 5, my lord.
Your good name, please.
Shikha Bhattacharya.
As PROCEEDINGS. Learned counsel for the respondent number 4 and 5. The petitioner has stated that he has been maintaining a current bank account number side over at Hatsingmari branch HDFC Bank. Will you make a response number 3? Post of. The petitioner has approached this court stating that his entire bank account has been kept blocked, allegedly due to receipt of 2 cyber complaints. Which are for suspicious transactions, credits amounting to rupees 1449.39 and rupees 18,242.27 respectively. First, issue notice returnable on so and so. As Ms. So and so has appeared accepted for 4 and 5, no formal notice. Extra copies 2 working days. Steps upon respond number 1 to 3 by speed post within 2 working days. Last of video on appearance of the so and so.
3009. For interim order, lordship. Apply the lordship.
Item 7.
Yes.
See, against the insurance ombudsman order, lordship. Next slide.
This is the only remedy.
Yes, lordship.
No other remedy for insurer.
No other.
Otherwise, law says that the award of the ombudsman is final.
Yes, lordship. There is no alternative.
As per the scheme,
That's it.
the award is there. So far as insurer is concerned, the order of the ombudsman is final and binding.
Yes, lordship. Fine.
Yes. Then law says,
Lordship, but in this case, there is no reason order, lordship.
how do that final and binding? And is there no other authority to prefer any appeal against the order of the ombudsman?
No.
Huh?
Only that.
Banking ombudsman now have another appellate authority.
That's
Banking ombudsman,
that's
after the ombudsman, now there is another appellate authority before the Reserve Bank.
yes, lordship.
So is it not there?
No, lordship.
Because all these are disputed facts.
That's it. Because in this case, lordship will find, lordship, our evidence was not at all considered, lordship. Why we repeated the claim, lordship? He did not indicate no FIR was filed. No FIR was filed. He
All those are very disputed questions of fact. And who had done what, whether he had prepared, purchased a new key set.
new key said, lordship.
All these are matter of evidence.
That is why the ombudsman have to consider all things, lordship. That was not considered, lordship.
What is the scheme? So, insurance. What is the scheme?
In Lordship, section 17, Lordship.
Section 17 is provided in a statute. Thereafter, not section 17. Insurance Ombudsman 2017. P32. P32. Now, this law says the award of insurance ombudsman shall be binding on the insurers.
That's
Rule 17,
7.
8.
That's
Then how can you maintain this repetition? That is not binding for the complainant. But so far as you are concerned, you have formed this body,
Lordship, but
you have formed this ombudsman.
as per Rule 15, for regional opportunity should be, hearing should be given, Lordship. Rule 17, one award must be based on the pleading and evidence brought on record. But our evidence was not considered, Lordship. Rule 17, award must be in writing and state region. Rule 73, compensation is subject to statutory limitation. And Rule 17.8, binding nature of the award subject to correct amended position. Lordship. But
Will
in
issue
this case,
notice
a
at this
policy
stage.
condition rule.
We'll issue notice at this stage. These are disputed questions of fact. We are to entertain or not. Whether he has done it, heard Mr. K.K. Bottle and counsel for the petitioner, first of the insurer of a vehicle. The petitioner is an insurer of a vehicle. Is the insurer of a vehicle bearing registration number AS01JC3069. Comma, belonging to the respond number 2. So the respond number 2 obtain an insurance policy from the petitioner insurer bearing number so and so, paragraph 2. Full stop. The response number 2 dash insured lodged an insurance claim before the petitioner insurer alleging theft on 12/12/2024, alleging theft of the vehicle, subject vehicle. First of the according to petitioner insured, comma, it appointed an investigator to investigate the claim and to ascertain genuineness of the alleged occurrence of theft. First of the investigator found that 2 keys were produced by the respondent number 2 that's insured, and the same were not original keys of the subject vehicle, as he had purportedly lost the original keys prior to the date of the alleged theft. First of where the respondent number 2 insured approached filed a complaint before the insurance ombudsman and the said
After repudiation of the claim,
after repudiation of his claim, and the said complaint was registered as page 30 ZUW-G-051-2627-0073. First of on receipt of notice, the petitioner insured submitted objection. First of the insurance ombudsman passed an award on which date? Any date? Date?
seventeenth, 10 July 2026.
14/7/2026. Holding that the repudiation of the claim by the petitioner insured is found to be unjustified and cannot be accepted.
Award dated 14/7/2026.
Who should do? And since the case is a case of theft, the petitioner insured shall settle the claim on total loss basis, subject to compliance with other policy terms. First of aggrieved thereby. Aggrieved by the award, impugned award dated so and so of the insurance ombudsman, the petitioner insured has preferred the instant deed petition, seeking setting aside and quashing of the award dated 14/7/2026. First of Para, it is contended that the binding character of an award passed under the Insurance Ombudsman Rules, 2017 cannot operate as an absolute bar against the exercise of the power of judicial review by this court. When an award of the Insurance Ombudsman suffers from error of law and non-consideration of relevant and material evidence and non-application of mind, matter would require consideration, issue notice, returnable on so and so. Steps upon the respondents by registered speed post. We need to work in this from today.
Interim should be conducted.
Whether ombudsman has any executing power, it will be a paper decree.
Yes.
If you defy, whether he has the power like a civil court. No. Where is the question of state? The prayer for interim relief is kept open for consideration on the returnable date.
3009.
If he has no executive power, then you have no fear. If he has come back,
Yes.
next day I'll pass the order.
Item 8.
Especially relating to my lord that issue of NOC by the deputies for registration of the sale deed, my lord.
Okay.
Uh,
So agree by inaction. Okay, hard Miss Anne Soikia.
My lord, may I pray, my lord, since the small issue is involved, waiting here for another 6 months, can it be disposed of, my lord?
I don't normally dispose of unless I have satisfied.
Yes, my lord, because
Let
of
them
that
respond.
I have stated, para 3 I have stated, since the, my lord, para 3,
Let them respond. Then we'll dispose of.
the
Hard
instruction, my lord, otherwise 6 months will take, they will not file a affidavit. That will
On the
delay more.
returnable date, on the basis of instructions, and
Yes, sir.
Soikia Learned Counsel for the petitioner, Mr.
Even when
As
the
doctor-
circuit officer forwarded, but my lord.
As
control-
Dr. Learned Standing Counsel Revenue and Disaster Management Department, Government of Assam, for the respond number 1, H.K. Hazarika, Learned Junior Government Advocate Assam, for the respond number 2 and 3. Full stop. The petitioner has stated that when did you file? Where is your application?
I might not. Of January 1925. 25. 9th of January,
The
29
petitioner
January.
company
29 January.
it is stated that the petitioner company purchased.
Not purchase, my lord.
Okay.
Yes, purchase, but sell, sell my.
Purchase or
invested.
agreement for sale or
No,
what?
my lord, purchase.
Had
He has
entered
paid full
into.
amount.
Huh?
Full amount he has paid,
Huh?
purchase.
No,
but
had
sell
agreement for sale of land or sale deed?
Sell deed registration. NOC is required for registration of the sale deed.
Oh, so sale deed is not
No,
registered.
sir, that's why. my lord,
Has entered into
Yes,
an
paid full
agreement
amount.
for is the proposed purchaser
Yes,
of a plot of land measuring 8 bighas, 2
Yes.
kathas,
yes, ma'am.
2 lessas, covered by tag number so and so and patta number so and so, situate at village Khena Alibari, Mouza Dokhin Rani, which revenue circle?
Polasbari Revenue Service,
Polahbari Revenue Circle, district
District Kamrup,
Kamrup. Kamrup or Kamrup Metro?
rural.
Kamrup,
Kamrup.
Assam. Subject line. With the owner, with its owner. Full stop. As it is a requirement to obtain a no objection certificate under section 21 of the Registration Act, as 1900, as amended, the petitioner submitted an application before the district commissioner, Kamrup,
Before the circle officer, my lord.
or before the respondent number 3 on 29/1/2025. First of it is stated that the petitioner has complied with all the requisite formalities at the time of submitting the application. First of it is
The
it
Mondal
is
report and
contended
circle
that
officer.
we are not into Mondal, we are into district commissioner or
Yes.
don't
Forward.
don't make
Thereafter-
this court to deal with Mondal only.
Sorry, no. He reported and circle officer
Then
forward.
you I will ask
Sorry,
that
madam.
the peon also you deal with
No, my lord.
instead of district
Just
commissioner or commissioner.
I'm stating facts.
Ms. Soikia has contended that though the application was initially processed, but at later point of time, the petitioner has not been able to get the exact status of the process of the application. Hence the writ petition. Issue notice returnable on so and so. As so and so appeared accepted, no formal notice, extra copies. Steps upon respondent number 4 by speed post within 2 working days. The respondents shall ensure that the region, the state to place, shall ensure to place the status of processing of the application for NOC of the petitioner on the returnable date.
30/09. 30th September, 30/09.
Hello, আগত দিব নোৱাৰি। মানে full payment fixed হবে। Hello, আগত দিতে পাই যাম। That's 2 weeks or 3 weeks. Obliged, my lord.
Item 9.
Please, your lord.
I'm appearing for the older respondent.
Okay. You want to obtain instruction or what?
No. Yeah, I will obtain.
Or notice?
Yes, notice may be issued.
Heard Mr. M. Ali, petitioner, and Mr. A. Hussain, learned counsel for the respondent number, all the
respondents.
Agreed by the act of keeping hold on the hold entirely in respect of a savings bank account number so and so maintained by the petitioner at Bisney branch of respondent Axis Bank Limited. The petitioner has approached this court by the instant petition, issue notice returnable on so and so as to say for all, no formal notice, last paragraph likhe dibo. What is the reason for keeping the entire account?
30/09. 30/09.
Please.
Daily list item 10.
May it please your lordship. The petitioner here in your lordship had earlier approached this honorable court by writ petition 6463 of 2025, your lordship, which was disposed of, directing the petitioners to apply for settlement through Seva Setu portal, your lordship, which they have duly done. And they were
Which
also.
one is that?
Lordship, 6463 order is in page number 84 and 85, your lordship.
84, 85.
They were given the liberty to
Then,
approach again.
at which is, Yes.
The acknowledgement receipts have been annexed in page 91 onwards, Your Lordship, where of the Seva Setu applications, Your Lordship, which was applied for in February, but was not considered yet, Your Lordship.
Okay.
And subsequent to the applications, Your Lordship, filing of the applications, this honorable court had also passed another writ petition 1563 in a similarly situated case, where Lordship, if I may bring your attention to page number 89, Your Lordship. Where Honorable Mr. Justice had observed that the learned, may I read, Your Lordship, the relevant portion?
Which paragraph?
Lordship, paragraph number 7, second sentence, around 7th line.
Paragraph 7.
7, Your
Okay,
Lordship.
let us read it all.
Lordship.
Yes.
So having attained the status of landholder by Section 4 of 1974 Act,
This is a question to be decided.
Lordship,
This is not yet decided. You are claiming it,
Lordship.
and court has observed that this is a question
Yes, Your Lordship.
is to be decided.
Yes, Your Lordship.
Right.
Yes, Your Lordship.
Not yet attaining finality. That
Lordship.
claim is not attaining finality.
Lordship.
Right. Already you have approached this court.
Yes, Your Lordship.
This is the order passed in a pending application or what?
Yes, Your
This is
Lordship.
who is this man? Is he the petitioner or what?
No, this is a similarly situated case, Your
No,
Lordship.
no. What you are, on one hand, you have filed an application for settlement of land, right? Which you are stating that they are pending. And no decision has been arrived at, right?
Lordship.
So, if these applications are not decided, come to page 91.
Lordship.
Read.
Your application for settlement of khas and ceiling surplus land has been submitted successfully on so-and-so date and your acknowledgement number so-and-so. Please use this acknowledgement number for tracking the application and for any future communication related to this application. If the application has been accepted by the Revenue and Disaster Management Department, the service shall be provided within 300 days. You may raise an appeal at so-and-so website if the service is not delivered within 300 days.
Now, what is the date of the application?
February 2022. Your Lordship.
Count 300 days.
26, Your Lordship. Sorry. Lordship.
Count 300 days. When the date of expiry of 300 days will arrive.
Lordship. Lordship, if I may make a humble submission.
So you cannot open multi-front. There cannot be any parallel proceeding. You have to wait for 300 days
Lordship.
because they also need time to process your application as you have claimed certain rights, right? The court has already said in a similarly situated person that it is a question to be decided. Now, which one you want to pursue? This one or that one?
Lordship,
Settlement of khas and ceiling surplus land, or your status as an occupancy tenant and as a right of khatian holder, which would flow through all the acts?
Lordship.
Which one?
Lordship, subsequent to the even several petitions that your lordship has passed.
No,
recently.
in those applications,
Lordship.
don't try to jumble up the facts. There no application for settlement of land was made or are pending, right?
Lordship.
Here, number of writ petitioners, they have filed an application for settlement of khas land. That application has been duly acknowledged in February 2026.
Lordship.
And in the application, they have said we would need 300 days to process.
Lordship.
And if we do not process, then they have to pass a region order,
Lordship.
either allowing your application or dismissing your application with a speaking order. In either way, you have a right to file an appeal. You have a right to file a second appeal. You have a right to file third appeal also nowadays. Right.
Lordship.
There you have made an application and you want this petition to be decided.
Lordship, my
See, it cannot be two ways.
Lordship. Lordship, my understanding of 1563 interim order, the one that we have just read here, the lordship had
There
observed.
you are the petitioners.
This is similarly situated.
Oh, no, don't say that.
But that section 4 of 1974.
No,
has
you
been-
cannot claim, see,
Lordship.
one is settlement of khas and ceiling surplus land.
Lordship.
There is a notification, right?
Lordship.
Under the land policy. That these are the requirements, eligibility to get settlement of ceiling surplus and khas government land, right? And it needs, I think, 50 years or something. Many criteria are there, 3-4 criteria are there. This is one. And on the other hand, you are saying about Gwalpara Tenancy Act and all this. Now, you have to decide which right you are claiming,
Lordship, the
right?
Lordship.
Which thing you are pursuing. There it is already pending. And it needs 300 days to process and to arrive at a final decision, right?
Lordship.
Now you are showing similar situated candidate. Then you have filed another writ petition when the applications are pending, yet to be decided. How you want to attack all the respondents from all sides?
Lordship,
This is not the proper way. You have to. This is what are the reliefs you are claiming?
Lordship, the claims of the petitioner is
If
that
the applications are pending, two parallel proceedings should not be there at the same time.
Lordship, it was observed in that
Because
150
your prayer is issuance of patta.
Lordship.
Same thing, you have already made the for same relief. You have made the applications.
It was directed to the petitioners in 6463 to apply for the settlement through the portal.
That is.
Lordship, so we
Then
complied with that.
Huh?
The applications were filed in compliance with that.
So in
But the claims
court,
of the
like Mr. Major Bhuiyan,
Lordship.
the court had, Coordinate Bench had directed you to file the application through portal, online. And online applications you have filed, right? Page 91 clearly says 300 days we need to process the application. Right?
Lordship.
So impatience is shown by whom?
Lordship, if I may clarify, Lordship, subsequent to 1563, Your Lordship, we had this understanding that
Where is your
inadvertently
previous order? Where is your previous order?
6463 is
Page again,
Lordship.
6463.
page 84.
Yes, these are the petitioners.
Yes, Your Lordship,
Then Coordinate Bench has directed you
to apply for the settlement.
to apply for the settlement,
Lordship.
right?
Yes, Your Lordship.
And not considered within a reasonable time.
Lordship.
para 85,
Yes, your lordship.
is it not?
Lordship.
And what is the reasonable time according to the
300
state
days.
respondent?
300 days. your lordship.
Then what more is required?
Lordship, the Khatyandars under 74 Act were also observed in another case that inadvertently and on wrong advice application was filed for settlement by the same honorable court. your
Who?
lordship. In
No,
page number
no,
89.
no.
your lordship.
You are the petitioners in
Lordship.
6463. Is it not?
Lordship.
If you are aggrieved by this observation, you have to file a writ appeal. Otherwise, you have to abide by this direction.
Lordship.
And you have abided by this direction.
Lordship, we have.
And you have filed these applications, right?
Lordship.
And these are under the land policy.
Lordship.
There is a notification. This is a notified public service,
Lordship.
right?
Yes, sir.
And provision is there that it should be decided within 300 days.
Lordship.
If you don't decide, you can file an appeal. If they dismiss, you can file an appeal. What does it indicate?
The subsequent order.
If you are aggrieved
Lordship.
by this page 85 direction, that by which your writ petition was dismissed, you should have filed an appeal.
Lordship, so, Lordship, we are not aggrieved with
That is what.
Lordship.
There cannot
Our
be
subsequent
2-3 proceedings
Lordship.
for the same relief.
Lordship. Understood. Our subsequent understanding of the
Your understanding is somebody else has gone in a different way. So let us also go and explore that way also. Then you have to,
Lordship, it said that
Mr. Major Bhuya,
Lordship.
page 85 is clear.
Totally, your Lordship.
Your petition was dismissed.
Lordship.
Am I clear?
Yes, your Lordship.
Huh?
Yes, your Lordship.
And subsequent directions, liberty.
Lordship.
And you have abided by that decision and filed these applications. So is it not, even if we say that you have a right to file an appeal, but still we can enter in a writ petition. But still, is it not premature?
It is, your Lordship. I agree totally. your
Yes. Is it not a premature? You have to at least wait
Lordship.
for 300 days.
But the
After dismissal of your previous writ petition,
this
this
filing
is to
was,
be with and cost.
this
After dismissal of the writ petition, the liberty granted to you to file an application under Seva Setu.
No.
You filed your application. Again, you have come.
Lordship, subsequent to filing
Third,
of the
Mr.
application,
I.S. Major.
Lordship, if I may make a humble submission.
All supplication made, but result is same. It is premature.
Lordship, subsequent to the filing of the Seva Setu applications, due to this other order, similar
Oh,
order,
that cannot be. That cannot be, sir.
we had come
That
to
can
this,
wise sense has prevailed. Right.
Lordship, in regard the 1974 Act, this observation
I
had
have
triggered.
entered in your writ petitions,
Lordship,
many writ petitions.
totally, your Lordship. I am obliged, your Lordship.
It is not that every writ petition is to be entered in just on the same ground.
Lordship,
They have explored earlier and the court directed. My entertaining writ petition will be contra to what the court bench had observed.
Lordship,
Is it not?
Lordship,
Earlier writ petition was dismissed.
Lordship.
My entertaining this writ petition now, will it be not in violation of the direction made by the coordinate bench?
The earlier writ petition was-
Mr. Don't make such submission now. Court had dismissed your earlier writ petition.
on the ground that they have filed jointly, your Lordship. The petition was dismissed on the ground that they had filed the
No,
representation.
liberty
jointly.
was granted to what?
Lordship. Lordship.
Oh, liberty was granted for what? Now somebody else has gone in a different way. So again, you have come before this court by filing another petition. When the process is pending, your applications are yet to be decided. Can do parallel proceedings be continued?
No, your lordship.
Then heard, Mr. IS, I'm dismissing your petition premature. Learned counsel for the petitions. Paragraph.
Of the under page 85. The rewarding granted only because of one of that reasonable time or consideration of the reserving time.
Oh, no, after that separate applications, even if they file,
They apply for us, that others are separate by individual.
once they have filed the application, they have to wait.
They have to, the 300 days, they clearly stated in that. That number is done.
Your lordship, if I may.
Where it is clear that it is observed that in the circumstance, such application is filed and not considered within reasonable time, the petitioner should be at liberty to approach this court again.
Lordship.
That, and plus the notification says that 300 days they need.
Lordship.
Thereafter, you may have a right.
Lordship, only because of the section 4 that we have given in page 16, your lordship, because to our understanding, that has granted them the status
Then
of
withdraw
land.
this
property.
application, come back.
Lordship, I will-
Withdraw those applications and come back with a fresh petition. That we are abandoning the right of getting that notified public service of settlement of khas and ceiling surplus land. Will pursue our right under the Tenancy Act as an occupancy tenant.
Lordship.
And because by virtue of the provisions, we have already become landholder.
Lordship.
Two things are different. One is settlement of land is different, and already claiming as a landholder is different. Am I
So,
right?
Yes, your lordship.
Other petitions are that we are the successors in interest of occupancy tenant during that zamindari time.
Lordship.
And by virtue of our inheritance, we have become
Landholder.
landholder. That is one.
Lordship.
And second, these applications are for settlement. Two things are different.
Lordship. It is clear, and
Have you understood?
yes, your lordship.
It is your choice. Either you claim as a landowner by virtue of the provisions of those acts,
Lordship.
or as an eligible person to get settlement on your own. Forfeiting the other claims. Which one you want to prefer?
Lordship, the claims of the petitioner will stand, the landholder claims of
That
landholder.
you have to establish.
Lordship.
That is a matter of consideration and examination
Lordship.
of all the Real Revenue records, your Khatiyan, then all the historical documents. That is one, and this is separate. Which one you want to prefer?
Lordship, we won the section for we may be granted, Your Lordship, to
Okay, I'm
withdraw
not,
withdraw
saying
it.
that- okay, it is with
Your
liberty,
Lordship. Yes.
with liberty. But
Your
I
Lordship.
cannot, you cannot pursue both. Was as a landowner and was an applicant for to become landowner.
Lordship, it is my inadvertent mistake, Your Lordship. I make my deepest apologies to you.
You have got yourself confused.
Totally, Your Lordship. Totally, Your
That
Lordship. I agree.
I am the landowner. That is one. And second is I want to be a landowner. These applications are I want to be a landowner. Have you understood?
Totally, Your Lordship.
I think I may be wrong also, but this is my understanding.
Your Lordship is.
And I have been given protection in all the other cases where you have claimed that you are a successor in interest of an occupancy tenant by virtue of a quotidian during the Jamindari time.
Lordship.
But this is not the case.
Lordship. Totally, Your Lordship. I understand.
Heard Mr. I.H. Major Bhuyan, learned counsel for the petitioners. Pursue your claim, but in the right way. Mr. J. Hendik, Revenue 1, H.K. Hazarika, 2 to 5. Mr. Majubhi has submitted that the petitioners at this stage is not pursuing the writ petition, and the petitioners be allowed to withdraw the writ petition, come out with liberty. With liberty.
Highly obliged, Your Lordship.
View of the above submission made by Mr. Madhavyan, learned for the petitioners, the writ petition is dismissed on withdrawal with liberty as sought for.
Item 11.
Yes, what is the order passed earlier? Which one? WPC number?
WPC number, my
Jackson. Heard Mr. A.H.M.R. Chaudhary, learned counsel for the petitioner. J. Hendik, Revenue and Disaster Management Department, Government of Assam, for the response number 1. And Mr. H.K. Hazarika, learned junior government advocate, Assam, for the response number 2 and 3. And this private respondents,
My lord, notice may not be issued.
let us, what is your repeat number earlier?
4422. 2026.
That is specific performance.
Yes, my lord. Same.
But here it is 99.
99.
Here it is 99/2025.
No, 99 2000.
We will not go into the civil suit.
No. For that order, my lord, order 43 rule 1, my lord. For challenging the judgment of order of the civil court, my lord. Under order for it is an appealable order, my lord. That we are going to file, my lord.
We cannot touch any civil court order in a writ petition.
Yes, ma'am.
Yata khali respondent number 4, 5 and 6 could be 4, 5 and 6. Same. 28/9/2020.
Yes, madam. It may be tagged with
28/9/2020 is
published.
Item 12.
May please lordships. My lord, my case is that, my lord, in 1998, my lord, I purchased a plot of land, my lord, of 1 katha and 5 lakhs, my lord. Still now, I am holding the said land, my lord. I have submitted all the documents, my lord. In the meantime, what happened, my lord? At the time of, my lord, widening of the national highway, my lord, excluding my land, my lord, except my land, some other plots of land, my lord, that is, my dag number is, my lord, 73. And my lord, other dag number like 72, 67, 62, and all the, my lord, acquired by the National Highway Authority, my lord. And suddenly, my lord, on my lord, last year, my lord, I have started a multi-storied building, my lord. And thereafter, suddenly on last 25/6/2026, my lord, just 3 months back, my lord, some officials of the National Highway Authority of India, my lord, in cooperation with, my lord, some officials of circle officer, etc., my lord, illegally erected the pillars, my lord, on my land, my lord. And that's why I have submitted several representations, my lord, before the authority, my lord. That is, at first, I have submitted one representation, my lord. That is 3/7/2026, my lord. That is at page 43, my lord.
You should notice, heard Mr. S. Ahmed,
Yeah, my lord.
learned counsel for the petitioner. Mr. J. Hendrik, who is Union, Miss R. Bora, Union, Miss P. Bora, learned Central Government Council for the respond number 1. Miss R. Bora, you're for Standing Council? NHAI for the respond number 2 and 3. Mr. J. Hendrik, learned Standing Council, Revenue and Disaster Management Department, Government of Assam for the respond number 4. And Mr. H.K. Hazarika, learned Junior Government Advocate, Assam for the respond number 5, 6, and 7. Post of para. The petitioner has stated that he is the owner and recorded pattadar of a plot of land measuring 1 katha 5 lesa, covered by tag number 73 and patta number 49, situated village Bola Vita, Mathauri Chowk, district, Bornagar Revenue Circle, district Borbera, subject plot. And the subject plot is situated on the southern side of National Highway number 27. So it is, the petitioner has stated that for the purpose of widening National Highway number 37, land acquisition process was initiated previously. And in the said land acquisition process, though the adjoining plots of lands, a few of the adjoining plots of land around the few of the plots adjoining to the subject plot under DAG number 73 were acquired under the provisions of the National Highways Act 1956, the subject plot of the petitioner was never part of the land acquisition process. First off, as the subject plot was not a part of the land acquisition process, the petitioner started to construct a building on the subject plot after obtaining due permission from the competent authorities. Full stop. But the petitioner has approached this court agreed by the steps taken by the respondent authorities in the NHAI and the district administration. Full stop. It is stated that on 25/6/2026, the officials from the NHAI and the district administration visited the subject plot and erected boundary pillars by covering a part,
my lord,
or a part or whole.
my lord, almost all, my lord, whole part, my lord.
Covering a substantial part of the subject plot without initiating any acquisition process and following procedure prescribed under the law. Full stop. As the petitioner has constructed the building up to the print level, the petitioner is nursing an apprehension that the respondent authorities might take action to the prejudice of the petitioner. First off, issue notice returnable on so-and-so as so-and-so appeared accepted no formal notice, extra copies within 2 working days. In view of the projection made by the petitioner, it is observed, in the interim that the respondent authorities in view of the projection made by the petitioner that without initiating any land acquisition process, the respondent authorities have erected pillars within the subject plot. It is observed in the interim that the respondent authorities shall not change the nature and character of the subject plot till the returnable date.
5th October, 05
Obliged,
10.
obliged, my lord. Much obliged.
Item 13.
There is no representation on behalf of the petitioner today on call. Yes, Mr. Chaudhary, what is the case?
Lordship, it's against GST registration cancellation.
Registration cancellation?
Yes, ma'am.
In what manner?
Due to non-submission of the return and show cause was given.
Show cause?
Yes, Lordship. He replied and opting for personal hearing.
It's a long procedure, I think.
Yes,
Enlistment
Lordship.
of the farm. Enlistment of the farm. GST AS MT 10. Notice for intimating discrepancies in a return after scrutiny. So it started way back in 2022.
Yes, ma'am.
Then mismatch. GST or TB.
Thereafter demand.
Page 18, Indu Sharma. So cause notice for cancellation of registration.
Yes, ma'am.
Then you have been served with notice 2/8/2025.
Yes.
For seeking clarification, your director submit your clarification, there you would undersign. Suo motu cancellation?
Yes, ma'am.
Huh?
Continuous non-submission of the return for more than 6 months. Lordship.
And order under 74 also?
74 also there was a.
Okay, Mr. B. Chaudhary. Plan standing out the finance and taxation department. For the respond number?
For 2, 3, and 4.
Miss? Name, please. On behalf of B. Sharma, Central Government Council 1, are present. In view of non-representation on behalf of the petitioner today on call, the case is passed for further due. Sundi.
Item 14.
May I release your lordship? My lord, I want to withdraw this petition, my lord, with liberty to file again, my lord.
Mr. S. Rama, learned counsel for the petition submitted that the petition wants to withdraw the petition with the liberty to file afresh. Mr. J. Henry Learned Junior, standing counsel, revenue and so 1. SK Hazarika, 2, 3, and 4 are present. In view of the above submission made by so the petition is dismissed on withdrawal with the liberty as sought for.
Much obliged.
15.
Please, your lordship.
All or what? Mr. I am Ali, petitioner.
For the
A.
respondent
Hussein.
number, lordship, for the respondent number 1 and 4.
1,
One
4
and
and
four.
5.
Oh, sorry, 1, 4
One.
and 5. Sorry, Lord.
1, 4 and 5.
Yes, Lord.
Okay. Still not item number. What is the item number? Previous item number?
It was 9, Lordship.
9. Same. Account number to change করে দিব আৰু 2 আৰু 3 2 কাৰণে Deputy Solicitor General of India 3 steps speed post last of it লিখি দিব current account Canara Bank Hailakandi branch
3009.
same date
Obliged, Lord.
Item 16.
May please, your lordship. Lordship, the respondent number 4 is the wife of the petitioner, lordship. In his instituted partition proceeding over a plot of land before the dispute circle, lordship. In this regard, a notice was issued to appear before this dispute circle for the petitioner, and he accordingly appeared, lordship. But whenever he have supplied filed the application to provide the application along with the relevant documents, that has not been provided to him. And subsequently, he have filed a representation before the district commissioner. And as well as a file.
This respondent number 4 is your wife.
Yes, lordship.
What she initiated?
She have instituted partition proceeding, lordship, before the dispute circle.
Partition proceeding.
Yes, lordship.
Partition.
Accordingly, lordship, a notice was issued to me to appear before hearing, lordship.
Which notice?
Page number 22, lordship. And I was asked to appear before this honorable dispute circle on 9/6/2026, lordship. Thereafter, I filed a representation to provide the application along with the.
You said in a synopsis that it is a partition proceeding.
Yes, lordship.
Right?
Yes, lordship. But the notice has been wrongly issued, lordship.
Come to page 24.
Yes, lordship.
Whom are shown as applicants?
Yes, lordship. The authority have wrongly inserted my name as a applicant, lordship. But practical issue is that a notice was issued to me for appear before the dispute circle on 9/6/2026, lordship.
It is a demarcation and mutation.
Yes, lordship.
That is what from the notice. সীমা নিৰ্ধাৰণ
Yes, sir.
আৰু নামজাৰি সন্দৰ্ভত আবেদন কৰিছে.
Yes, sir.
Circle officer does not understand or what? You mean to say that he does not understand what he is doing?
Yes, lordship. Actually, thereafter.
Yes, Mr. Hendrik. He does not understand. Your circle officer does not understand what is partition and what is namjari and Hima Nidharan.
Well, this is given the Himan Nidharma demarcation.
Huh? He says that he is not the applicant.
Lordship.
And he said partition proceeding.
Lordship. Well, so my learned
Hima
friend,
Nidharan and namjari Hondarabhat.
but they did not annex any application, which application he was seeking on there.
No, he said that his wife,
Lordship.
estranged wife,
Lordship.
submitted an application for partition. Partition of what?
Partition over the land which I had purchased jointly, Lordship.
Jointly,
Yes,
Then
Lordship.
it should be one demarcation.
Jointly, Lordship.
partition.
Yes, Lordship.
How much land?
এক কথা চাৰিল আছে, Lordship.
She wanted to partition it.
Yes, Lordship.
Huh? Circle officer is not understanding her application. This is what you say.
No, Lordship, I subsequently, on the date of hearing, Lordship, I appeared and filed a representation to provide all the documents and the application.
But it shows that you are the applicant.
Yes, Lordship, that was wrongly issued, Lordship.
And how can, who were the purchaser in the sale deed?
A purchaser, me and my wife jointly, Lordship.
Jointly.
Yes, Lordship.
With jointly, they have purchased a portion of land also. Malad, they are again seeking the partition, malad, that should be malad demarcations of this regarding malad that.
What you want?
Lordship, I need the copy of the application and of the documents submitted by my wife, Lordship.
Application only. Get the application from the circle office. I mean, it turns out to be a joint application
Yes, Lordship.
containing your signature.
No, Lordship.
Turns out to be. If
Yes.
then you being an assistant professor of a medical college,
Yes, Lordship.
next day you be ready. Because you have said it is a partition proceeding. Circle officer is not understanding it to be a partition application. He understood it as a namjari and
Demarcation.
application. If you represent before this court very wrongly, be ready as an assistant professor of a medical college. Right, Mr. Hendik or
Hello.
Mr. Goswami?
Lordship,
You get the application of the proceeding. Let us have a copy. Let us have a copy,
Yes, Lordship.
whether it is a partition proceeding or a demarcation proceeding. Because your wife may be estranged,
Yes, Lordship.
has a right to file an application as a co-owner for demarcation and mutation. As a result, you and your wife's name will be mutated. We don't know about partition. Let us have this. Mr. Hendrik, heard Mr.
D. Burman, Lordship.
D. Borman learned counsel for the petitioner. But as an assistant professor, you run the risk. And Mr. J. Hendrik, you represent all?
Lordship.
Standing counsel and junior government advocate, Assam for standing counsel revenue for the respondent number 1, 2, and 3. Full stop. The petitioner has stated that the respondent number 4 has initiated a partition proceeding in respect of a plot of land which the petitioner had purchased. Full stop. The respondent of 4 on receipt of the application took cognizance on it and issued a notice to the petitioner on 25/6/2026.
Lordship, a first notice was issued to appear on 9/6/2026, Lordship.
Where is that?
First notice was
Where is that?
page number, Lordship.
25/5/2026.
Yes, Lordship. First notice was as page number 22, and second notice was
22.
subsequently I filed a complaint before District Commission.
Second notice of 36, page 27.
22. I read always the vernacular. I have read vernacular.
Sorry, Lordship.
Page 36 also.
Page
36.
36, Lordship.
five 2026. Treating the application mistakenly as an application for demarcation and mutation. Post of a similar notice was again issued by the respondent number 3 to the petitioner on 20/07/2026. Post of para. It is the case of the petitioner that he purchased a plot of land measuring 1 katha 4 lessa, covered by tag number 469 and the patta number 1263, at village Dokhin Gaon, Sonaiguli, with him and the respondent number 4 as purchasers. Full stop. Para. The petitioner has approached this court stating inter alia that he is not an applicant in the partition proceeding initiated before the respondent number 3 by the respondent number 4, and therefore, he submitted an application before the respondent number 3 on
9/6/2026, Lordship.
9/6/2026, seeking a copy of the partition application and other relied upon documents, and also for deferment of further proceedings initiated by the aforementioned 2 notices. Post of. Para, in view of such projection, Mr. Hendick, Learned Counsel, appearing for the respondent 123, shall obtain a copy of the application from the respondent number 3, on the basis of which the notices, dated 25/5/2026 and dated 27/2026, are issued to the petition. Please the case on search.
31st August, 3108.
3108.
Item 17.
May I please, Lordship? Lordship, the petitioner is seeking appropriate direction for fair investigation, Lordship. Lordship, the petitioner has lodged an FIR, Lordship, dated 4/7/2026. The FIR is at page 17, Lordship. Kindly, Lordship. Although, Lordship, the first portion of the FIR, Lordship, it is reflecting that matrimonial dispute, Lordship, and
Studying.
Lordship, page 70.
Police did not, your wife left.
Yes, Lordship.
Taking the minor daughter with him, right?
And subsequent.
Yes, let us understand.
Yes, Lordship.
Then you lodge an FIR.
Yes, Lordship.
Or the wife lodged an FIR.
Wife lost.
Or somebody else. Respondent number 6.
That's one number 6.
Who is he?
He's the driver, Lordship.
Okay, her Paramar. Okay, he lost the FIR.
Yes, Lordship.
Okay, registered?
Not registered.
Not registered. They have to lodge
There
an
are
FIR
the petitioner,
before the court below keep acting in concert. Then they decamped with 1,80,000 gold
1,80,000.
ornament,
yes,
12 lakh, 10 lakh,
and car,
contractor license, other important documents, bank passbook, Toyota Hyrider. Okay.
and the
Went to Marcus English School, petitioner stand. Then took away the minor child. Lost ZD entry. Unable to establish communication with his minor children. Okay. Then lost a written FIR. Okay, let us now see your FIR.
Page 20, vernacular.
Page 20. You want some action against your estranged wife and her paramour. You have to file appropriate proceeding before others, before
Lordship,
different forum.
my limited.
1 second. If you want that your children have been taken illegally and detained, you file habeas corpus. If you want custody, you file custody application.
Lordship.
Right?
Lordship. And now, Lordship, subsequent development.
Thereafter, you wanted to, you lost this FIR. Then what happened?
Lordship, 2-3 days before, Lordship.
Then thereafter, superintendent of police.
Yes, I have
You have filed.
submitted representative
Now-
for the SP and the city.
And what is the law?
Lordship,
What is the law?
should go before the magistrate under 175. Lordship. Yeah, Lordship, my limited prayer, Lordship.
Three
because-
forums. If you have any dispute with your wife
Lordship.
regarding her promiscuity, seek appropriate relief before the family court. If you say that your children are taken away illegally and detained by somebody else who does not have the right to retain custody, file habeas corpus. But if you want to have the custody of your children from your wife, file custody application. Now, regarding cognizable offense, if you say that this has made out a cognizable offense, then you pursue before the OC, then SP and before.
Then 170. Otherwise, Lordship, habeas corpus is now also limited version, Lordship. That is the main issue, Lordship.
So custody.
Custody lordship, problem is that lordship, no tracing lordship, how custody will be.
This is not the way.
That is the problem, lordship.
This is not the way to seek relief.
Others, lordship, subsequent development is happened, lordship. The son of the petitioner, lordship, the son of the petitioner, 3-4 days before, lordship, he succeed to, lordship, flee from the custody of the.
So he is back in the school.
Lordship, then he communicated with the petitioner, lordship, to rescue him, lordship. Thereafter, lordship, the petitioner, lordship, rescued him, lordship. And lordship, this information also communicated to the police station, lordship. But the police
Heard
station.
Mr. J. Islam reaction. Heard Mr. J. Islam
No,
and counsel
any
for the
action is
petitioner
taken,
and Mr.
Taking the.
Your FIR is not registered.
No.
Not registered.
Not registered, lordship. Taking the lordship, they are replying that this is family dispute, lordship. This is the
Mr. N.
problem,
Goswami Lion, Junior Government Advocate Assam. For all the.
2 to
Response number
5.
1 to 5.
1 to 5.
Post of the petitioner has projected that the petitioner alleging commission of, stating that cognizable offences have been committed. Laws and FIR before the officer in charge Bilaki Police Station on 4/7/2026, stating that cognizable offences have been committed by the accused persons named therein. Full stop. It is stated that the officer in charge Bilakipara Police Station, despite receipt of the FIR, did not register the same in spite of the fact that the FIR disclosed commission of cognizable offences. Full stop. The petitioner stated that thereafter, he forwarded a complaint to the Superintendent of Police Dhubri by post on 5/8/2026. Full stop. As no action has been taken either by the officer in charge Bilakipara Police Station and the Superintendent of Police Dhubri, the petitioner has approached. CDS is not in picture.
Okay.
Has approached this court invoking the extraordinary jurisdiction of this court under Article 226 of the Constitution of India, seeking an inter alia direction to the respondent authorities to consider an act upon the FIR the petition has submitted on 4/6/2026 and to register the FIR if the information mentioned therein are disclosed cognizable offences and to conduct a fair and impartial and effective investigation in accordance with law. Full stop. Para, on a query made to the learned counsel for the petitioner, it is submitted that whether any approach is made by the petitioner before the jurisdictional magistrate in terms of section 156 within bracket 3 CRPC or section 173 within bracket 4 RW section 175 3 Bharatiya Nagorik Huraikha Honita 2023. The learned counsel for the petition has fairly submitted that the petition has not yet approached the jurisdictional magistrate under the stated provision of law. Full stop. Para, having regard to the observations and directions made in the decisions of the Supreme Court in Sakari Bosu versus State of Uttar Pradesh and others, 2008, 2 SCC 409, Sudhir Bhaskar Rao Tambe and Hemant Yasban Dhage, 2016, 6 SCC 277, and Tujal Biswas, Atavar and another versus State of Maharashtra and others, 2026, 5 SCC 273, and the provisions contained in section 156(3) CRPC and or section 173(4) BNS RW 175(3) BNSS, this writ petition this court is of the unhesitant view that this writ petition is not to be entered in, as the petitioner has not approached the jurisdictional magistrate till date. Post stop. It is observed, the writ petition is therefore not entertained. Post stop. While not entertaining the present writ petition, it is observed that the petitioner as an aggrieved person has the liberty to avail the remedy under the BNSS by approaching the jurisdictional magistrate under section 173 within bracket 4 BNSS RW section 175(3) BNSS by following due procedure and formalities as laid down in those provisions.
Highly obvious.
Daily list, item 18.
May it please, my lord?
Yes.
Petitioner, my lord, have challenged a notice whereby the petitioner, the NHIDCL has directed the petitioner to remove the so-called encroachment from the national highway.
Notice, which page?
Yes, my lord. The notice, my lords, will find at page 71. This is a notice purportedly under section 26 of the Control of National Highways Land and Traffic Act of 2002, my lords.
Yes.
Yes, my lord. If my lords, if I can just place the facts in question, my lord. The petitioner had purchased the land in question, my lords, by a registered sale deed of 16/6/1996, my lords, which my lordship will find at page 27 on it. The original, my lords, starts at page 31.
Yes.
The petitioner had purchased a plot of land measuring 2 katha, covered by DAG number 176, periodic patta number 6 at Horu Pothar Gaon, Moran Moza. Page 31 onwards is the copy of the original sale deed. The description of the land lordship will find at page 33. Thereafter, my lords, a Jamabandi was also issued, my lords, where the revenue records were amended to include the name of the petitioner. Page 40, serial number 9, my lords.
Yes.
The name of the petitioner appears, my lords. Now, he has also been paying regularly paying the revenue, my lords, Khazana. The landholding certificate in question has also been issued, my lords. Thereafter, a separate DAG also has been issued in favor of the petitioner. Lordship will find it at page 66, my lords. 67 is the copy of the original. A new DAG has been created, being 299, DAG number 299 under patta number 141, my lords.
Yes.
Now, the petitioner, my lords, on the plot of land, he had intended to construct a G+3 residential, my lords, RCC building. My lords. For this very purpose, at page 65, lordship, the Khori Moran Gaon Panchayat has also issued a NOC, my lords. That will, lordship will find at page 65.
Did you reply?
My lords, respectfully, my lord, the notice is not in consonance with the mandate of the very same provision it relies on, my lords. Ironically, my lords, the notice, if lordship takes up the notice at page 71,
Yes.
I have also passed a copy of the relevant act, my lords. Section 26, if lordship kindly takes up at page 7 of this copy, my lord.
Yes.
Subsection 2 is the provision under which the notice has been issued. When, as a result of the periodical inspection of a highway, land or otherwise, the highway administration or the officer authorized by such administration in this behalf is satisfied that any unauthorized occupation has taken place on highway land, the highway administration or the officer so authorized shall serve a notice in a prescribed form on the person causing or responsible for such unauthorized occupation, requiring him to remove such unauthorized occupation and to restore such highway land in its original condition as before unauthorized occupation within the period specified in the notice. Subsection 3 is important. The notice under subsection 2 shall specify therein the highway land in respect of which such notice is issued, the period within which the unauthorized occupation on such land is required to be removed, the place and time of hearing any representation, if any, which the person to whom the notice is addressed may make within the time specified in the notice, and that failure to comply with such notice shall render the person with specified in the notice liable to penalties, summary, eviction from the highway, land in respect with so and so under subsection 6. Now, interestingly, my lords, the notice at page 71 is completely silent as regards the details of the land in question, the highway in question, and also, my lords, in gross violation of the principles of natural justice, it does not even provide for an opportunity of personal hearing or filing a representation against the laws. It defeats the very purpose of the subsection 2. Now, there are, my lords, rules framed under this very act, being the yes, my lord. The rules, my lord, relevant rules, lordship will find from page 75 onwards. I will not trouble lordship with the entire set of rules. There is a schedule, my lord, which provides for a prescribed format of a notice, my lord. At page 87, lordship will find the notice.
Yes, initiate ECL.
My lords, I will like to take instructions on the matter. And my lords, the petitioner has also been given a chance to represent. And the address is also mentioned. And the other contention that the
Yes, so 3 days,
4 days.
as per schedule 3. You have given 1 more days.
4 days.
Instead of 3 days, you have been given 4 days.
4 days.
The authority is specified.
And
Now, my lords, another aspect perhaps lordship has to consider is any violation, my lord, the natural corollary of a notice under subsection 2 is subsection 6, my lords. Here, my lords, the notice said actions under section 27 shall be taken if he fails to reply or does not remove the structure, my lord.
And the my lord area, my lord, lordship will see the starting. It has been observed that right of way of the national highway at GNS 553 plus 654 left hand side of NH 37. I'd like to take instructions, Madam Speaker.
When the requirement is, my lords, to provide a place and time of hearing, and that has perhaps not been carried out, my lords, respectfully.
Noted that any presentation statement is to be submitted within 4 days.
Page 87 is the prescribed format.
26-6. Well, notice that 87 well mentions sections, subsection 6 of 26. Where, my lord, if you read, my lords, it is a case where no notice was served. Notice is served. Okay, I can take instructions on this matter, my lords. Perhaps next week.
Only thing missing is the date of hearing.
Yes.
Otherwise, also,
Only hearing of representation.
I have also put for other grounds, my lord. Yes, that is one of the 4 contentions I have raised.
Third, Mr. B. Chaudhary, Learned Counsel for the petition. Who is for one?
Union, my lords.
Mr. D. Gogoi, Standing Counsel. NHIDCL for the respond number
234, my lords.
Mr. N. Goswami, Learned Tribunal Advocate Assam. For the respondent number 5 and 6. The petitioner has stated that he is the owner and and in possession of a plot of land measuring 2 kathas, covered by DAG number 176, covered by DAG number 299 within bracket old or new within bracket 176 old and patta number 141 new stroke 6 old, situate at number 2 Horubathar Gaon, Moja Moran, District Dibrugarh. Full stop. Where the petitioner has approached this court after he has been served with a notice by the respondent number 2. Who is he? Respondent number 4. As the highway administrator or an officer authorized by the highway administrator under section 26 of the control of national highways within bracket land and traffic bracket close act 2002, whereby the petitioner has been asked to remove unauthorized occupation and to restore the highway land. Full stop. As part of notice, the petitioner has illegally constructed his premises within the right of way of national highway at CH 553 plus 654 LHS of National Highway 37. Postal, where it is the contention of the petitioner that the petitioner is in occupation of the subject plot of land and there is no encroachment from his part. Postal, he has further submitted that although the notice dated, what is the date of the notice?
It is undated, my lords, but I have specifically stated we
Though
received the notice
the
on 18.
notice, though in the notice, within bracket undated, the petitioner is provided an opportunity to submit a representation within 4 days before the respondent number at the office of the respondent number 5, there is no mention of the place and time of hearing of any representation, and as such, therefore, the notice is not in conformity with the provisions of subsection 2 of section 26 of the 2002 Act. Full stop. Mr. Google and standing counsel in its IDCL has submitted that he needs some time to obtain instructions in a matter. Issue notice returnable in so and so. As so and so has appeared accepted, no formal notice, extra copies. Within 2 working days, the counsel for the petitioner shall serve a copy of the petition along with an extract to the Deputy Solicitor General of India, Landed Deputy Solicitor General of India. Within 2 working days from today, for service of notice of the respondent number 1. First of having regard to the projection made, the subject land is a periodic pata land and has not encroached upon the National Highway number 17, and the infirmity projected for sections 26(2) of the 2002 Act. It is ordered in the interim that there should not be any further action against the petitioner in terms of the notice within bracket undated annexer H till the returnable date against the petition till the return.
My lord is fixing a date.
30/09, 30th September.
30. My lord, that will be too, because my lord, here what will happen, though the petitioner claims that he is in receipt of the notice, that letter is undated. There's no averment how he received that. There's no averment. So, my lord, if there's these cases of the highway genuine, then we will suffer, my lord, because if the instructions are very clear that is issued mistakenly, that's a different thing. But if the facts comes out otherwise, then, my lord, that will be
If
I prefer early
yes,
date, my lord. That's
it cuts both ways. If you take action, if
No, I'm
you
not
take
opposing
action
that. I'm not
into a
I'm not
pata
opposing
land,
it.
then
I'm not opposing that, my lord. I just I'm
there
saying
is
early
no,
date. Early date.
no
my lord.
such time. We have to go by the business of the court.
My lords. Early date if possible, my lords. Highway, it's there, my lords, this national highway. my
Not
lords.
possible.
Oh, let's-
Order stay vacating, item 19.
While your reply will decide the case on the returnable date. File your response.
My lord will, in that case,
File your
my lord will kindly observe that.
If the responding
lords,
authorities
my lord, kindly
file,
observe that.
Mr. Gugu has submitted that he will file a counter affidavit on behalf of the respondent NHI DCL authorities within 2 weeks from today.
My lords.
So if such counter affidavit is filed within 2 weeks from today, then the petitioner shall file its reply affidavit, if any, within on or before the returnable date.
My lords. Oh, let's-
Item 19.
So applications for a stay vacating or perhaps Malad for some modification of the order. Well,
What is the order passed?
Malad at page 29, Malad
20.
of my eye. Also may come to page 31. Malad. Your point.
Just position of a plot of essential content. Where is that 10/9/2025 notice?
My lord,
10/9/2025 notice.
my lord, in the writ petition, my lord.
Okay, just
My lord, at page 79 of the writ petition.
okay, okay. Just a minute. $79. You said 79.
My lord, 79 of the writ petition, my lord, in the writ petition. Notice. 79.
Hmm. Or Assamese version is at page 80. Now it is ESIC.
My lord.
Namot Potta Bhukta. So it is periodic patal.
My lord.
On what ground, Mr. Gupta, you have challenged?
Chauhan.
Chauhan, you have challenged on what ground?
My lord, petitioners
Only one or two lines.
violation of my lord land policy. My lord. Violation of provision of land policy. My lord, 2019.
And on what ground this order you have wanted to vacate?
My lord, here, my lord, if I may permit, my lord, here, my lord, this the particular piece of plot of land, we have sent a proposal to the government that we want to build a dispensary as well as branch office. And because the land was visual, my lord, so we had to, the government had to go through a process. Vacating a part of land.
The reservation
Yes,
under
ma'am.
Rule 895
Ma'am.
perhaps.
And after that, my lord, we have acquired the land. We have paid the necessary amount also, my lord, which if a lordship may find it, IA.
No, no.
Well, I
Come to page 80.
80, my lord. Yes.
He said, circle officer said that it is a periodic patta land,
My lord.
Miyadi Patta 1156.
My lord.
Right?
My lord.
Now, under what provision he has got the authority and jurisdiction to issue such a notice?
But that I am coming, my lord.
No, no, tell me. Under what provision of law? Once it has become periodic patta land,
My lord.
wherefrom he will derive authority and jurisdiction to issue a notice to an encroacher who is in encroachment of periodic patta land. This is the foundational question.
Because perhaps because we have already bought the land from the government.
That
That is, we have
whether he has power under Rule 18.
My lord.
Okay, he has simply issued a notice. He has not given the source of his power. Let us assume he has derived his power from Rule 18 of the settlement rules. Whether the settlement rules speaks of any periodic patta land.
My lord, no. My lord, perhaps, my lord, if I may place the case, my lord, what is
No,
happening?
no. Tell me it is a periodic patta land or not.
My lord, it is a, my lord,
1156 or not.
my lord, the land which I have been allotted, this is my
It is 1156.
No, my lord.
Tag number 550.
My lord, if your lordship may come, page 44, my
So
lord.
tell me only these two facts. Tag number 550.
No, my dark
and-
number is 833, my lord.
Hmm?
833, my lord. The dark number which I've been allotted is 833, my lord.
Then you have no business with the
I have no
tag
business-
number
my lord,
550.
I have no business with that if it is the dark number, my lord. My lord, my case is that, my lord, my land, which I have bought, I paid the premium. The land has been mutated in my name, and I've also allotted contract to the contractors to construct the boundary wall. There, my petitioner is challenging this, my lord, the dark number that he's been residing in this dark number. In the prayer.
Which number?
My lord, dark number 883. If your lordship may come to the writ petition, my lord, the prayer portion. Page 30, my lord. B, my lord. Prayer B. On page 30 of the writ petition. B, my lord, prayer B.
B for Bombay.
My lord, this is applause to the prayer portion. They read in, if I may, my lord.
They have been seeking
To settle the land.
settlement of their settlement in dark number 833,
833.
right?
There
And they are in occupation of dark number.
833, my lord, for.
Huh?
My lord, since 1954, the petitioners have been in possession.
No, then why you are seeking setting aside of this notice?
Well, because that, my lord, this order, my lord, has been passed, my lord, without any notice to us, my lord, issuing any.
No, which one? Page 80?
79, my lord, 79,
Huh?
80.
80.
Yes, my lord.
This is limited to dark number 550, patta number 1156.
That is, my lord.
If you are sitting on dark number 833, why you are seeking quashing of this notice?
This, my lord, subsequently, this, my lord, Myadi Patta number 1156, 550 has been created, newly created.
You want to say dark number 833 was government dark number.
Yes, my lord, government land.
Now, after conversion,
Yes.
after VGR
No,
conversion,
Sarkari land.
he said
Yes.
that de-reservation was done.
Yes, sir.
So dark number 833 has been converted into dark number 550
Yes.
and patta number 1156.
Yes.
And that has been settled with the applicant.
Yes, ma'am.
ESIC.
Yes.
Right.
Yes.
And the court has directed to maintain status quo.
Yes.
With respect to this particular. And this particular notice, prima facie is unauthorized.
My lord, if I'm lordship may come to page 45, my lord, the number has already been changed in the Jamba Mandi, my lord. After we have.
Right. We are trying to find out page 80.
My lord.
Right. Whether he has jurisdiction to issue such a notice. Have you understood?
I understand.
When it is dark number so and so, it is not a government land. When he issued the notice, it has already been converted into periodic patta land with separate dark number and periodic patta number, which has been settled with you. So whether this authority can direct the alleged unauthorized encroacher by this kind of notice to vacate a plot of land under periodic patta.
Perhaps the government will have to answer on that.
Yes, government answer. Today also I have seen one order in some of the repetition. Once it is periodic patta land, circle office does not have any authority and jurisdiction to issue such a notice.
This is also under file some repetitions.
No, question is about this.
And page 90.
They have challenged page 80. And it is clear, 550 dark number, periodic, Myadi patta number stands. And what else you have challenged, Mr. Chauhan?
My lord,
10/9/25, my lord. 10/9/25 is there. And my lord, to settle, my lord?
Settlement is different. First.
Yes.
They also challenged the communication to which the land was supposed to
Mr.
be.
25.
Smith, you have to think about your remedy.
Well, perhaps because we have bought the land, the government is supposed to provide the land encroach free,
But they did not.
but it is our right, our right has been hampered.
Now, as a periodic patta holder, what is your right?
Well, to occupy, to take possession of the land.
To get the position, in what manner? If it is encroached.
Not if I mean that the whole land is not encroached, only a part of it, but that has
Tell
already
me, by read code,
my lord.
how can we exercise to remove something from periodic patta land? Give us one authority of this code. One authority. I'll rely on it and pass down. Right?
Absolutely, but
Right from
yes,
1886.
my lord.
Right, and give you the time period. Get an order from 1886 Assam Land and Revenue Regulation. Get one order of any bench of this code. I'll rely upon that and allow you.
Well, I'm only seeking a modification of the order because.
Right, that is why I'll modify it. Right?
Right. And also one more.
But I'll rely on that decision. Maybe illegal, I'll say I'll be bound by the coordinate bench decision. I'll pass the order.
He's challenged the notice, my lord, that the body him to.
And the coordinate bench has passed the order rightly, questioning the jurisdiction of the circle officer to issue such a notice, directed maintain to status quo, maintain status quo.
But here, my lord,
Give me some authority or show us from the statute. You have the statute, show us.
I'll go to him because I'm not prepared to. I've not been stated, but here, my lord, coming to the only that limited portion, my lord, that the boundary wall. Which,
When the writ petition has challenged the particular notice and that particular notice, looking at the authority and jurisdiction of the person who had issued the notice, has passed an order, interim order of status quo, I don't find anything
and if I may submit only last, my lord,
to vacate that order.
Well, if I may submit one submission, my lord, in the prayer portion, my lord, he has also challenged the communication whereby the land was about to be allowed.
That
to
is
be
one
exercised.
main challenge is that to that notification, sir.
No, both, my lord. He has also challenged the communication whereby the land was supposed to be transferred to the ESIs. And accordingly,
We are
yes,
examining whole writ petition or the interim order.
well, interim order.
As on today, interim order. Show us any authority from the statute or from any judgment of this court that circle officer can issue a notice to a noticee to vacate periodic patta land. Very simple. Question is very simple. So answer will be very simple. Yes or no. That will determine the whole writ petition.
Well, then the direction be given to the government also to file
Oh,
the affidavit.
no, you are the applicant.
Well, yes, I'll show, my lord.
Show us.
My lord.
You are the applicant. Right?
I'll go.
You have to stand on your own feet.
My lord.
Otherwise, you will decide the writ
But I'm
petition.
not challenging the, I'm not saying the.
Mr. Smith, I am saying that to vacate it, show us from the statute, I said, right? What are the governing statute? Assam Land and Revenue Regulation and settlement rules framed under it. Or interpreting those provisions, any authority that circle officer has the jurisdiction to vacate periodic patta land. That's all. Very simple. Okay. Heard Mr. M. Smith, Learned Counsel for the petition applicant. Stroke respond number 18, WBC number 1009/2026, and Mr. R.H. Chauhan, Learned Counsel for the opposite party number 125 stroke writ petitioners. Also heard Mr. S. Dr. Learned. Yes, you can assist. Your circle officer. Tell me. Tell me. What? No, whether he has the power.
No.
No. He says no.
Then I have
So you have to
compensate
swim
my-
against the tide. Mr. S. Dr. Lawrence Standing Counsel, Revenue Department for the OP number 7 and N. Goswami, Junior Government Advocate, 8, 9, 10, 11 OP. Okay. Mr. Smith has sought a week's time to complete his instructions. First of praise allowed, lays the case on service.
Date, any date?
1409, 14 September.
Get the district clarified.
Rajma. Item 20.
Yes, Mr. Chaudhuri. What is your case? Your
Supplementary list item 53.
Yes.
My lord, if your lordship sees that, my lord, communications made, my lord, thereafter again by WhatsApp, my lord.
Page.
Yes, my lord. Not carrying the file. Alright, it's the last page, my lord, last pages. On 14/8/2026, my lord, this court was pleased to, my lord, go through the entire thing, my lord, and my lord say that as per clause 11 of that, my lord, prior notice was required to be given. And lordship says held because of that, my lord, that suspension order will remain inoperative. Thereafter, your lordship has, my lord, said that he will be allowed to play in the Kanpur games. my
Would
lord.
you participate in that
No, my lord.
tournament?
No, my lord.
Why?
Because, my lord, in the meanwhile, that is why I have given in annexure 1, my lord, that TTFI was disbanded, my lord, by the government of India because of irregularities, my lord, in the executive committee. And there was no secretary general acting at that point of time, my lord. And now, my lord, because of that, this tournament now starts from, my lord, this is on 29th of this month, my lord. And there, my lord, Assam Table Tennis Association says that, my lord, because of that, that order was only in respect to the Kanpur games, my lord, not for, my lord, any other games, my lord. So that is how, my lord, I am again before your lordship, my lord, to clarify on that point, my lord, because they have misunderstood the entire order, my lord.
Hard, Mr. G. Chaudhuri. Yes, state. Learned counsel for the applicant, read petitioner, and Mr. J. Henry, learned junior government advocate Assam for the response of the opposite party number. One, respondent number 1. First off, the applicant as the writ petitioner has preferred the accompanying writ petition. WPC number 4326
Of 26.
2026. To assail an order of suspension issued against the applicant writ petitioner by the opposite party, that's respondent number 3. Full stop. The on when the writ petition was listed on 14/8/2026. This court, while issuing notice to the respondents, returnable on 16/9/2026, had also passed an interim, also extended interim relief to an extent. Full stop. As one UTT National Ranking Table Tennis Championship that's 2026 within bracket quote the UTT Championships that's 2026 unquote for short was scheduled to begin under the auspices of under the aegis of the Uttar Pradesh Table Tennis Association to be conducted by the Uttar Pradesh Table Tennis Association under the auspices of Table Tennis Federation of India (TTFI) at Kanpur from 16/8/2026 to 23/8/2026, wherein categories of under 11 and under 13, U-11, U-13, for boys were included. This court, keeping the order of suspension in abeyance, in the interim, directed the respondent as opposite party number 3, that is Assam Table Tennis Association, within bracket ATTA, and all other respondent authorities concerned with the matter to facilitate and allow submission of the application of the petitioner for participation in the UTT Championships that's 2026. Full stop. Para. The instant interlocutory application is filed stating inter alia that seeking a direction to the opposite parties as respondents to allow on which one you want? A recent one?
Yes, my lord. It starts from 29th, my lord. I want in all the games, my lord, until it is disposed of, my lord. Let him play, my lord, in all the games which is conducted by the Assam Table Tennis Association or, my lord, under the aegis of the Table Tennis Federation.
To allow participation of the petitioner, applicant petitioner, writ petitioner, in all the sports events organized by the opposite party, thus respond number 3, comma, ATTA or under them or by any other district sports associations under the aegis of the ATTA. Until such time, the interim order passed on 14/8/2026 remains in force. Postal. But it is ever that after the interim order, after 14/8/2026, the applicant petitioner made endeavor to participate in the UTT Championships 2026. But due to paucity of time and suspension of recognition of the opposite party, that's respondent number 2, that is TTFI. By an order dated 12/8/2026, by an order number, page 16, dated 12/8/2026 by the Ministry of Youth Affairs and Sports, within bracket Department of Sports, Government of India, as a national sports federation with immediate effect. The participation of the applicant writ petitioner in the UTT Championships 2026 could not be materialized. Post of para. The applicant writ petitioner has stated that the occasion to file the instant application seeking the relief, mentioned above, has arisen due to another decision taken by the opposite party, thus respond number 3, whereby the applicant petitioner has not been, whereby the participation of the applicant writ petitioner in
The UTT Assam ranking table tennis championship two thousand
yes,
twenty-three.
sir. In another tournament, UTT Assam ranking table tennis championship 2026, scheduled to start from 29/8/2026 has been stopped. Full stop. It is stated that the information regarding stoppage of participation of the applicant as writ petitioner has come to the knowledge of the applicant writ petitioner from a WhatsApp message within bracket page. Annex 3. Post. Para. From the contents of Annex 3, which is stated to be a WhatsApp message, sent to the secretary.
Lakhimpur District Sports Association.
Lakhimpur District Sports Association, Lakhimpur, by an official of the opposite party, that's response number 3, it is noticed that the name of the applicant petitioner was sent by the secretary, Lakhimpur District Sports Association, to the opposite party, that's response number 3, on 22/8/2026, for participation in the UTT Assam Ranking Table Tennis Championship, that's 2026. In response, the opposite party, that's respondent number 3, had clarified that the order dated 14/8/2026 pertains specifically to participation in the UTT Championships, that's 2026, held at Kanpur, and would have no bearing on or connection with the tournaments organized by the opposite party, that's response number 3. It is mentioned that the applicant writ petitioner has been suspended by the opposite party, that's response number 3, until further notice, and therefore he is not eligible to participate in tournaments organized under the aegis of the opposite party, that's response number 3, during the period of suspension. Post. With such projection, the sender of the WhatsApp message has requested the secretary, Lakhimpur District Sports Association, Assam, to withdraw the name of the applicant petitioner from the entry submitted by the Lakhimpur District Sports Association for the UTT Assam Ranking Table Tennis Championship, that's 2026. First off, para. It is stated that the UTT Assam Ranking Table Tennis Championship, that's 2026, is scheduled to commence from 29/8/2026, and a draw is scheduled to be prepared on 27/8/2026. And it is in the above obtaining fixed situation, the petitioner, applicant petitioner is compelled to approach this court by the instant application, seeking relief. Full stop. Para. The facts and circumstances which led the applicant writ petitioner to approach this court by the writ petition, WPC number 4326/2026 have already been unnecessary relevant facts have already been taken note of in the order dated 14/8/2026. Full stop. Therefore, it is not necessary again to recapitulate the facts and those facts and circumstances in the present order. Full stop. But for all intents and purposes, the order dated 14/8/2026 is to be treated as part and parcel of this order. Full stop. Para. While issuing notice, this court had the relevant excerpts of the order dated 14/8/2026, which is relevant for the instant application, are quoted here in below, paragraph 70. From a reading of the above paragraph, it is evidently clear that the interim relief is in interim reliefs extended to the applicant petitioner, writ petitioner, are in two parts. That is, are in two parts. Firstly, the suspension of the applicant writ petitioner from participating in all tournaments conducted under the ATTA with immediate effect and until further notice. Having been found prima facie contrary to clause 11A and clause 11B of the Memorandum of Association of the Table Tennis Federation of India, is to be held inoperative in the interim. And secondly, the applicant petitioner. And secondly, the respondent authorities, opposite parties, the respondent authorities, shall facilitate submission of the application of the applicant petitioner for participation in the UTT Championships, that's 2026, on 15/8/2026. Full stop. Para. From the contents of the WhatsApp message, from the contents of the decision, which has been conveyed by the WhatsApp message within bracket Annex 3, it is evidently clear that the opposite party, that's response number 3, has misread the interim order passed by this court on 14/8/2026. It is reiterated, therefore it is reiterated that the decision of the opposite party, it is reiterated by the interim order dated 14/8/2026. The decision of the opposite party, that's response number 3, to suspend the applicant petitioner from participating in all tournaments conducted under the aegis of the opposite party, there's response number 3, which naturally includes all the district associations under it, comma, is held to be inoperative till the interim order dated 14/8/2026 is in force. Meaning thereby, the applicant petitioner is to be allowed participation in all the tournaments held under the aegis of the opposite party, that's response number 3, and its district associations, if his participation in U11 category and U-13 category boys events is permitted by virtue of his All India rankings, which is presently ranked, who is presently ranked 61.
68.
68. Full stop. It is therefore directed that it is ordered that the applicant petitioner entry, the opposite party, that's response number 3, and its district association, including which association? Nagaon Sports Association. And its affiliated district association shall facilitate participation of the applicant petitioner in the UTT Assam Ranking Table Tennis Championships, that's 2026, and all other tournaments, comma, as noted above, comma, till the interim order dated 14/8/2026 is in currency.
My lord, one small direction, my lord,
I
because
already লিখি দিয়ক, issue notice কৰি দিয়ক, একদম ওপৰত। Issue notice, returnable on same date.
small direction, my lord, because the window has been closed to allow, my lord, open the window and allow his participation.
You are against
What to do, my lord, a boy of 10 years, my lord.
to facilitate such permission, comma, the opposite party, that's response number 3, ATTA and all other respondent authorities connected with the matter shall facilitate and allow submission of the application of the applicant writ petitioner for participation in the so and so. It was a key নামটো নতুন নগাঁও যে
This is held in.
by,
Guwahati.
by tomorrow.
This is held in Guwahati, not Nagaon.
Which one?
This 29th, from 29th, it
No.
is to be held in Guwahati, not Nagaon.
এইটো এনেকে লিখাৰ নাম দিলো UTT Assam Ranking Table Tennis Championship
Yes.
dash 2026.
Yes, sir.
President to be here, Nagaon.
By today is what day?
Today is my lord 26th, my lord.
26.
27.
I am the. My lord, a copy
আৰু
of this-
ইছ্যু নটিচ বাকীখিনি লিখি দিব আগতো
Copy of this.
Return
order
negotiation.
in the course of the day, my lord.
that is the problem. You always come at 11th hour and ask for this.
My lord, what, my lord.
This is no, this is creating problem.
My lord.
You will get it.
Or a signed copy of by the court master, my lord. A signed copy of this order by the court. master.
Correction is a different. That is same thing, no? It's not possible. A last part to likhi dibo. A page 28 or last part to likhi dibo.
On that day, my lord, this order had to be uploaded on the 15th of August, my lord. I had to approach somebody, my lord, to get it uploaded.
Last part to order to isnake likhi dibo. Last line.
I am the.
Issue notice kori dibo.
Daily list for admission, item 20.
Yes, sir. Yes, Mr. Roy.
The last station commissioner has filed the affidavit. That does not improve the submission, my lord. That does not improve. It is normal affidavit filed by them. They say that unless they get the records, they will file a detailed affidavit. Lordship,
What was the case about?
but the land was taken. by
Some
our-
land.
Yes, our land was taken for school, my lord.
Okay, okay, okay.
And without acquiring the land has been taken, my lord, without any acquisition proceedings.
What kind of affidavit has been filed?
They say that, my lord, that the ask inspector of school to give them certified copies of orders and all that, then they will file a detailed affidavit. Para 6 may be seen, my lord. And so far the land is concerned, my lord, there is nothing about the land they have stated. They want para 6 and para 7 will clear it, my lord.
What you are making, Mr. Kosik, I think you are making mockery of the court. My para 7 statement. This petition is pending since 2022, right?
Yeah.
4 years have gone by. And secretary is making a statement that to file, crave leave to file additional affidavit in the present case. Who, as and when same is advised to do so. Who will advise him? Who will advise him? Tell me.
Paragraph 7, my lord.
7. I think this is 7.
No, my lord.
That is your affidavit or who?
No, no, my lord.
Para 6.
Paragraph 7 says, my lord.
Oh, this is respondent number 8.
Yes.
Where is your affidavit?
That is from page 90,
Starts from page 90
94.
with 94.
94.
So
Nothing has
basically-
come, Mr. No affidavit has come. I read the affidavit of respondent number 8.
Oh.
But
It is not on record.
Yes.
Number 2 has filed it. madam.
In fact, the day when the respondent number 8 was made to appear personally, my lord, in fact, Lordship took note of this affidavit and gave a liberty to us to file an affidavit by the secretary. Now, if your Lordship kindly finds.
I have
the-
not gone through the affidavit. It is not
Yes.
part of the record. How
Oh.
can we deliver it?
Yes, yes.
Get the affidavit on record. Heard Mr. J. Roy, Lana, Senior Counsel, stated by Mr. Miss so-and-so. For the petitioner, B.J. Toljar, Lana, Senior Counsel, stated by Mr. P.K. Medi, Lana, Counsel for the respondent, Junior Government Advocate for the respondent number 1, 5, 6, 7, and 9. And Mr. B. Kaushik. Learned Standing Council Secondary Education Department for the response number 2, 4, and 8. Mr. Kaushik has submitted that. As per office note dated 24/8/2026. No affidavit has been received by the section till date. So Mr. Kaushik has submitted that. When?
12/8/2026.
An affidavit on behalf of the respondent to has already been filed on 12/8/2026.
26.
As the affidavit of the respondent to stated to have been filed on 12/8/2026, is not on record. Office to release the case on so and so. With the said affidavit of the respondent to on record.
16/9.
My lord, can it be 79, my lord,
Silo, normal date.
or 21/9?
Silo. Normal hearing date.
21/9 বন্ধ আছে
22, my lord, or 23.
23rd.
30. Obliged, ma'am.
Items 21 and 22.
Yes, Mr. Jory, that has come unlisted,
It has come, my lord.
but unlisted.
No.
No, in a production list.
For the IA, my lord.
Now I am not going to let it be on some other day
My lord, my,
to deliver it because
my
see,
only problem is, my lord, yesterday they have attached it. My restaurant has been attached. Day for yesterday.
50/51.
And my lord, how things are moving is very, I'll just explain. Only thing is, my lord, only formality wise that IA was not there, otherwise Lordship has heard the matter, my lord.
right, because I have fixed
Only
some
problem is,
other.
my lord, tomorrow and day after tomorrow I'm out of. Tomorrow can we take a chance at 10:30, my lord? As a subject to your lordship.
Tomorrow, one problem is there. I might not sit tomorrow
Oh,
because something
okay,
developing. So I might not.
okay.
Friday I'll sit
Yes.
in all probability, and also Monday also. But tomorrow again, since I have heard a little bit in the matter, so tomorrow another court will
Only
take up.
thing is they've attached it, my lord. That's why, my lord. If you-
Lordship, although the attachment.
No, we're not hearing on merit. We are only trying to accommodate. You were not there on Friday.
My
Because I
colleague,
have
my
already-
colleague would be there, of course, my lord.
Can it be on Monday on priority basis?
All.
On priority basis, I'll take it.
Only thing is, my lord, they will not take any further coercive measure in the meantime, my lord.
What already?
Yes.
Already seizure.
Only attachment has been done.
No, Lordship, auction notice has been issued and on 8th September, the auction is to be conducted.
Okay, Monday.
Monday.
31st August.
Monday, IA today as some production list concern.
296.
Production list conjure. Okay, Ian Choudhury, Senior Counsel Estate by Anne Along, Government Advocate 30, Bijay Taluda, and Senior Counsel Estate by PK Methi, Revenue, P Gupta.
Lordship, may I also pray that all the Bakijai proceeding files be bought on Monday so that all the records are before your Lordship.
Madam,
Well, it is not a
Lordship,
matter of
records-
this nature.
records
That
will
everything
be
has to be
done,
done in this
as
case only.
Learned Counsel for the parties have expressed urgency, release the case, release the IA, along with item number
50/51.
on Monday.
Monday.
31/08.
We'll consider.
The records would be required. My humble
We
submission.
don't know. I have not looked into the file.
Maybe, Your Lordship, this petition has to be filed, my lord, against the inaction on the part of the state respondent, not taking any.
They have filed any affidavit?
Affidavit, yes. From the affidavit in opposition filed by the respondent number 2, my lord, the district commission, my lord, it has come to our notice that the circle officer or the Hajur Circle has already initiated a proceeding for eviction of the enclosures from the grazing.
The
grazing reserve.
petitioner claim to the official of Dokonia Reserve.
Initial petition was filed for against the inaction, my lord, on the part of the.
Just a minute, I have to understand. So encroachment on grazing reserve.
Grazing reserve.
This is a subject matter.
My lord,
Okay, they have filed affidavit.
affidavit, my lord,
By through whom?
by the district commissioner, they are just number 2, my lord.
Yes.
Tamil,
Yes,
my lord.
what sum and substance, what they have,
By the annexure A, my lord, page 70 of their.
what they have stated?
That they initiate their notice has been issued, my lord, under rule 18(2), my lord, to the enclosures, my lord. And
Yes.
the some of the enclosures actually to whom these notices were issued, my lord, they approached this honorable High Court, my lord, by filing 2 read petition, my lord, that so they have also annexed the annexure as annexure D, page 76, my lord. By which the petition was disposed of with a direction to the enclosures to for filing their objection, my lord, against this notice under rule 18(2), my lord. And to dispose of their objection accordingly, my lord. And for filing their objection, they were given 15 days time from the date of the order filed by this honorable High Court, my lord.
Yes. Now what we have to do today?
Only, my lord, as soon as the petitioner might be given an opportunity to appear before the circle officer, my lord, at the time of hearing objection by the by the enclosures, my lord. Yeah, with that, my lord, direction, my lord, this petition can be disposed of, my lord.
We have taken steps in all the cases, my lord. We have specifically stated, my lord, there was a joint survey by the revenue officials and my lord. And we have demarcated the area where there are government lands, my lord, which are encroached. We have already issued notice. In one case, we have hearing was taken place.
If possible, we'll try to dispose it on Monday. If possible.
That is possible, my lord.
And
It
see
can
the
be
senior
disposed of.
counsel for the petitioner and Mr. B.J. Talder and senior counsel. Appearing for the state respondents have submitted. You have,
Item number 22, my lord.
who are you? What is your,
Same as the enclosures, my lord.
your prayer is in alignment with this petitioner or opposite?
My mudra is this, explaining mudra.
No, you want,
I am from Ramdev Mudra.
you want eviction or?
My eviction is protected by earlier order of the.
No, who has got this, why these are two, who has fixed this? Huh? You are in, from Dokonia Grazing Reserve? Huh? No, Ramdia Moja doesn't mean that it is Dokonia Grazing Reserve.
29,200.
No,
Oh.
are you any, do you have anything with Dokonia Reserve Forest? Grazing Reserve?
Lordship, why it was tagged, my lord, it can be seen from our affidavit at page 68. That in his case, there was a interim order. They are the encroacher.
No,
And
are they encroachers in Dokonia Grazing Reserve?
No. They are different, they are not. This is maybe a completely different case.
belonging to Tapabori village.
They are saying Tapabori.
Tapabori.
They are saying Dokonia Grazing Reserve.
No.
maybe in the same district, but may not be.
May not be the same.
But here is a case of grazing reserve, and law is settled on grazing reserve. There is no doubt about this grazing reserve issue.
Right.
Khas land, it is a different issue. So we are disintegrating, not mixing your case with government khas land and grazing reserve are two different. We are segregating it. They are, have they filed affidavit?
No.
Oh, yes.
Mutar nahi.
We put it, your case some other date. You are having interim order.
Yes.
Heard Mr. N.C. Das, Learned Counsel, Senior Counsel, estate by Miss. Learned Counsel for the petitioner in 21. And Mr. S. Jaman, Learned Counsel for the petitioners in 22. Also heard Mr. B.J. Talder, Learned Senior Counsel, estate by Mr. P.K. Medhi, Learned Counsel for the state, Learned Junior Advocate Assam for the state respondents and Miss Ann Border, Learned Standing Counsel, Revenue Department. Post up. The Learned Counsel for the parties have submitted that the parcel of land involved in 21 pertains to Dokonia grazing reserve, which is purportedly under Rule 18(2) of the settlement rules framed under the Assam Land and Revenue Regulation, and the parcel of land involved in 22 is a parcel of land which is government khas land, which is covered purportedly under Rule 18(3) of the settlement rules, and therefore, the issue involved is different. Issues involved in the two petitions are different. In view of the same, the two petitions are delinked. Post up. Raise the case. Raise the petition WPC number 3099/2024 on 31st.
30 was fixed.
And the petition. It will take you on to better.
28 September, 2809.
20.
She will kindly takes.
The interim orders, wherever passed earlier, shall continue till the next.
Item 22, your lordship, an affidavit was filed by the circle officer, your lordship. Item 22.
I have noticed.
Yes, there it is
The-
stated that.
Dokonia.
Yes.
Dokonia.
Yes.
Dokonia. That
Paragraph
affidavit was filed in
Paragraph
their
number
case
3.
also.
Okay, I can do both the cases. 31st.
Item 23.
May I please, Lordship? Lordship, some accommodation may be given, Lordship. Affidavit already prepared, Lordship, and has already been sent for vetting, Lordship.
Miss
M. Tiwari.
Tiwari, M. Tiwari, for the petitioner and Border Revenue 1 and 2. Mr.
B.C. Musari, my lord.
B.C. Musai,
SC
Standing Counsel BTC
BTC,
for the respondent number 3 and 5, and Mr. J. Hendik, Learned Junior Government Advocate Assam for the respondent number 4. Mr. Musa, Standing Counsel BTC has submitted that the affidavit on behalf of the BTC authorities is under preparation and has sought for further 2 weeks' time to file the affidavit and to produce the relevant records.
Yes, Lordship, already we have.
First up, raise the case on such. Praise the Lord.
Mass
Praise the Lord, raise the case on such.
Item 24.
May I please, your lordship? Lordship, reply has not been filed by the respondent.
Yes, who is to file? CGC. What is the case about? What is the case about?
Lordship,
To complete the instruction, C. Borua. Yes. Okay, Mr.
P. Bhattacharya, lordship,
P. Bhattacharya, petitioner,
on behalf of B. Pukaisa, lordship.
petitioners. Mr. 5, 6, and 11. Mr. Miss N. Bordoloi, Revenue 1. Mr. J. N. D. Learned Junior Government Advocate Assam for the response number 7, 8, 7. Mr. Borua, representing the response number so and so, has submitted that the counter affidavit on behalf of the said respondents has been sent for vetting, and given 3 weeks time, he will file the counter affidavit. Post of the prayer is allowed. This is the case.
Date may be fixed, lordship.
25th September,
What is the case about? What is the case about?
Lordship, actually, petition is
Any
writing because
procedure complete his instructions to whether there is any prosecution.
of the Delhi schedule rates, lordship. they
Release
will-
the case after 3 weeks on a date.
3 weeks.
Lords.
Deeply obliged, lordship.
Item 26.
Pursuant to the order of 10th of March, 26.
What is the issue left about?
Issue left is on interest only. I would like to address on interest along with.
But not today.
I'll place some judgments whenever your lordship is.
Let us have a fix a hearing date.
Yes,
That amount has been paid.
Which one? 20 or
principal
something?
principal amount has been paid.
Now
but
it is
it's
interest.
Only the interest which is left open.
Some hearing when you are convenient.
Would it be September, Milan? 24th?
September.
24th?
September.
Yes.
Can it be the first part of October? Otherwise, it will not 2025. It will come down in the list. It will not be possible. Nowadays, there are MSc appeals. Up
I'll
to
go by whatever is convenient to your lordship.
Find out. Find out. Commerce. MSc who has Okay. A. Pukan for the petitioners. And Mr. B. J. Taludar, learned senior counsel listed by Mr. P. K. Medil, learned junior government advocate for all the respondents. Post of the learned counsel for the parties have submitted that the requisition can be taken up for final consideration
On the issue of
on a
interest.
convenient date on the issue of interest. Post of list the case on side.
8th October, 0810.
Is it okay?
Yes. Obliged.
Item 27.
Yes, Mr. Some other matters took time. Till Friday, I have also some. All the other one. So, till Friday, I have some deadline. Yes, interim order is there.
Yes, my lord, it is there.
What is the issue? Similar issue tagged or what?
No, but it's different one, my lord.
Different.
Different, my lord. Section 75, so violation of section 75(5) and section 75(7). Amount was mentioned, the so-called notice was less, order was confirmed for more amount. And there was-
Okay.
that- and
Okay. Okay, Mr. R. Special Learned Counsel for the petition is present, standing counsel. Finance and Taxation Department for the respondents is found absent today on call. Full stop. In view of non-representation, Toma let the case be listed on side date after 13. After 13, the interim order passed, I shall continue till the next date of 16. Why use the issue up at 3 PM? That one.
For
Okay,
disposal.
okay.
2 points, my lord.
One is more demand amount is more than the notice amount.
Yes.
And second one,
There was no PH, my lord, with
75.4.
24, my lord.
Okay. Mr. Gogoi is also not there.
Yes, my lord. Much obliged.
25th September,
Much.
2509.
বেশি হয়ে যাবো নি 25 তাই দেবো সম্পাদিব নোৱাৰিলে দিলেও এইটো বেলেগ এইটো বেলেগ এইটো বেলেগ
Item 29.
Yes, Mr. Hawk.
Instruction of.
Lordship, we have prepared the affidavit, the same has been sent for vetting, so. Lordship-
Okay, Mr. ABT Hawk, learned counsel, but a petition is present. Ms. P. Thapa, learned standing counsel, on behalf of standing counsel, Panchayat and Rural Development Department has submitted that the counter affidavit has been sent for vetting and the same will be filed within
Within a week.
2 weeks' time. Full stop. And has just sought for, Ms. Thapa has just sought for listing of the case after 2 weeks. List the case on so and so, the interim order.
Okay.
2309. Item 30.
Sanoki Coach. Yes,
Lordship, in this case, Lordship petitioner seeking
notice upon what? Newly implemented respondent. You have filed.
yes, Lordship,
Who is the newly implemented respondent?
Serista Lordship.
State Council can represent?
Has to, High Court can. SC High Court.
High Court. Okay. Heard Mr. D. Borman, learned counsel for the petitioner. Ms. N. Bordolo, learned standing counsel, Revenue and Disaster Management Department for the respondent number 1. And Mr. B.J. Talder, learned senior counsel, registered by Mr. P.K. Medi, learned junior government advocate, Assam for the respondent 2 and 3. So, let notice be issued to the newly implemented respondent number 4. So, notice is made returnable on so and so. So, it is submitted by the learned counsel for the parties. It is submitted at the bar that the learned standing counsel, Gauhati High Court, could accept the notice on behalf of the respondent number 4. On behalf of the newly implemented party, respondent number 4. So, in that view of the matter, the learned counsel for the petition shall serve a copy of the petition along with annexer to the learned standing counsel, GHC, within 3 working days from today. So, Tito did this, it release the case on.
1809. 18 September. Item 31.
Hanan. Which are the other 2 petitions?
Number 36, 37 and 38.
36, 37, 38. Any affidavits are filed? Not filed.
This one, I have received one instruction, Lordship.
This one?
31.
File and
Lordship, yesterday I have received
file the affidavit. You're for respondent number 1.
one.
1 or 2, I think. Heard Miss
Yes.
Yes,
Um,
Mr.
S. Loskar, learned counsel for the petitioner. Mr. B.J. Talder, learned senior counsel, registered by Mr. K. Medil, 1, 3, 4, 5, and 6, and Mr. S. Dr. learned standing counsel, Revenue Department, Government of Assam, for the respondent number 2. Full stop. Mr. Dr. has submitted that he has received the necessary instruction to file the counter affidavit on behalf of the respondent number 2 and has sought for. So, Mr. Dr. has thus sought for 2 weeks' time, has sought for and is granted. He is therefore sought for. No, again, Mr. Dr. has sought for and is granted. How much time?
2 weeks, Lordship.
Okay. 3 weeks time to file the counter affidavit on behalf of the respondent number 3. First of, release the case concerns.
23rd September, 2309.
Interim is there.
Non-interim.
First
No interim was there.
Lordship.
I have passed the order in item 31 only.
Okay.
32.
Wait, please, Your Lordship.
Bank account is freeze, your lordship.
Lordship, I am for the respondent, all the respondent, Lordship. For 1 and 2.
Yes, only 2 respondents. Yes.
Yes, Lordship.
Yes, anything.
Yes, Lordship, I have an instruction on this matter. On 4th of June, we have received a notice under section 94 and 106 of BNSS from Cyber Center of Excellence, CID Crime, Gandhinagar, Gujarat, on this particular bank account and a dispute of 1 lakh.
Okay, 106 also.
Yes, Lordship. From
Yes.
Gandhinagar, Lordship.
May I pray that that amount may be kept as VN and the
Dear,
account may be.
dear Ketawat.
And
Hard Miss F.
re-KYC is-
Hussain.
Lordship, re-KYC is required.
Huh?
For re-KYC is required,
Okay.
Lord.
Hard Miss F. Hussain, learned counsel for the petitioner. And Mr. A. Hussain, learned counsel on behalf of Mr. M. Sarawat.
Yes, Lordship.
Learned counsel for both the respondents. Para 2 to লিখি দিব। And second, third paragraph, the second paragraph, Mr. Hussain has submitted that he has received the necessary instructions to facilitate for the purpose of disposal of the writ petition. Come on, the writ petition is taken up for final disposal. তাৰপিছত five paragraph লিখি দিওঁ। From
Lordship, from Cyber Center of Excellence.
Cyber Center.
Cyber Center of Excellence, CID Crime.
Just a minute. Cyber Center
Cyber Center
of
Excellence, CID Crime, Gandhinagar, Gujarat.
CID Crime,
Yes, Lordship.
Gandhinagar,
Gujarat.
Gujarat.
Yes, Lordship.
So any suspicious credit?
Yes, Lordship.
1 lakh.
Yes, 1 lakh, Lordship.
And you're referring to some 106?
Yes, we have received a notice on 106 BNSS regarding this bank account
Okay,
on this particular dispute, Lordship.
you have received a notice. It is current or savings?
Lordship.
Current.
Current account.
এই কারেন্ট করে দিব দেই যত কারেন্ট হ্যাঁ চাই ল'ব
Current account.
copy paste করে নিয়ে দিব। Okay. 1 lakh lien.
Item 34.
Yes,
No, they send one letter, 6 some time not.
Miss
In 34 and 35.
Akhtar for the petitioner. Ms. Tinglung, on behalf of Mr. R.K. Talukdar, Learned Standing Council, NHAI and NHIDC, for the respondent number 1, 2, and 3, and Bordolo, Revenue 4, and Goswami, repeat 5, 6, 7. Mr. Goswami has submitted that he has been informed, Mr. Goswami has sought for and is granted how much time? Further 4 weeks time. Yes, Ms. Tinglung, you are also there involved. You have been directed to pay interest.
Yes, Lord.
Huh? Both Ms. Tinglung and Mr. Goswami have sought for are granted 3 weeks time to file their respective counter affidavits. List the case on sides.
3009.
Already decided 12%.
Yes, Lord.
Yes, next one.
Same Lord.
So, Iman, 35. After, again, same. Same.
Item 36.
Receive instruction. Okay. Miss, এইটো কিমান নম্বৰ আছে ঘৰটো? Miss,
36, 37.
I have forgotten your name.
Yes, Losper.
Lost God. Petitioner.
31 আছে.
J. Hendrik.
327.
Number 2 আছে. And N. Bordoloi 2 আছে. Mr. Hendrik has submitted that he has received the necessary instructions to file the counter affidavit and has sought for and is granted 3 weeks time to file the counter affidavit. List the case on so and so. The interim order passed earlier on 37/2026 shall continue till the next day of listing. This is 36. 37 is same?
Same.
Same. 38 is same?
All lots of.
Same.
23rd September. Item number 39.
Interim as a silo, what do you do?
We have received the instruction also. Paradise instruction also.
Received.
Yes, Lordship.
Now you're into bulldozer. Bulldozer photographs are there, right? So bulldozer. This man is there in the picture.
No, Lordship, as per our instruction, Lordship, the petitioner has no possession over the subject plot of land. Lordship.
Who has said? Circle officer.
Yes, Lordship.
Circle officer.
Circle officer, yes, Lordship.
He will be saying so. I want an affidavit from Deputy Commissioner.
Lordship.
And revenue. Clearly, this man is seen, circle officer is seen behind a, what do you call it, is JCB.
Lord.
Along with the JCB with his mobile. Is it not? Page 25?
Yes. Yes, Lord.
He's the man
Yes,
with the mobile
Lordship.
and with the JCB behind. We don't need circle officers.
Lordship.
His presence is clear. Is he denying his photograph? Hmm? Is he denying? He is the man.
Lordship.
Six. Sorry, against the.
Where is the environment? Where is the environment? He is the man.
Paragraph 5 here. Paragraph.
Paragraph 5. What is his response to paragraph 5?
Married, Lordship. The enclosed land is situated at Pumatia River, which is one of the rivers that constantly changes her course during flood season and becomes disastrative. Considering the priority of the flood situation, the demolition was carried out for public interest. Where the plaintiff, it should be prisoner, has illegally constructed storehouse with roof seats for keeping stock of stone, sand, and other construction materials without prior permission from the concerned government authority.
What does he say about page 14? That page 14, annexer 3, Roman 3, serial number 374. And the deposit of premium. Premium, right?
Lordship, yes, premium.
Yes, what does he say?
The land revenue tax payment received clearly reveals that the tax paid by the plaintiff was for number 2 Tengapur, but not for Sengmai Doloni, where she illegally encroached. Moreover, as per norms, Khazana must be paid annually by any registered or.
But he said it is not 2 number Tengapur, somewhere else petitioner is constructing. Is it so? Okay, you file your affidavit.
Yes, Lord.
1 week. 1 week. Right? Make it 1 week.
Lord. The interim may be extended, Lord.
I've heard Mr.
NJ Daimari.
Petitioner. N. Bodole 1 and Mr. H.K. Hazurika. 2 and 3. Post of Mr. Hazurika has submitted that he has received necessary instruction to file the counter affidavit on behalf of the respondent number 3. So, sir, he has prayed for 3 weeks time to file the 2 weeks time to file the counter affidavit on behalf of the respondent number 3. Post of the praise allowed, leaves the case on so and so. The interim order passed, regress and continue till the next of lives.
1609, 16 September. For orders, item 40.
Right, please, your lordship. Lordship, as per Lordship, court order.
Mr. Your name, please.
A.K. Kanu, your lordship.
A.K.
Kanu,
Kanu,
lordship.
learned counsel for the petitioner. Women and Child Development, who represent? He is present, post of. as per order dated 26/5/2026 of the Lodima Court, service of notice upon response number 4 is presumed to be complete. Full stop. In view of the fact that the service of notice upon the response number 4 is presumed to be complete, and there is no appearance on behalf of the response number 4 till date, list the case in the appropriate column on so and so for appearance of the response number 4. The state respondents are to ensure that their counter affidavits are filed before the next date of listing.
23rd September. Item 11.
11?
Regarding my notification 56, my lord.
Hmm?
Notification 56, my lord.
56.
Date of issuance of
4,
notification.
5, and 1 minute. Why it has come?
Orders, my lord, on the date of issuance of notice, my lord, that council will not avail so notice by issued, my lord. Now, names have been shown, my lord.
Who are the respondents? Union of India, anybody represents? Okay. 4, 2, 3,
2, 3, I will take lordship.
Mr. Chaudhary, 4, 5, 6, 7. Huh? Okay. Heard Mr. R.S. Mishra, counsel of the petition, and Mr. K.J. Counsel on behalf of Mr. S.C. Kyle, and senior counsel and special counsel CGST for the response number 2 and 3. Full stop. Mr. Chaudhary, B. Chaudhary, Lion Standing Counsel, Finance and Taxation Department has submitted that he would represent the response number 4 to 7. Full stop. As all the respondents are represented. When the other case?
28 or 28, 9 months.
Only is the case on 28/9/2026.
Then interim order.
Interim order passed, I guess, will continue field.
42. Item 42.
In this case, I have filed an affidavit in opposition, but the same is not on record. I may grant it further 2 weeks' time to bring it on record, my lord, because
Copy has also been served upon me, that they have not served any copy to.
it is not reflected in the.
Mr. B. Kaushik, Lion Counsel for the petitioner. Mr. N. Borua. Lion Counsel for the respondent number
Respondent number 1, 2, and
1,
4.
2,
3 and 4.
3 and 4, 1 to 4. And who represents this other?
My lord, for 6 and 9, I am being.
Mr. S. Dr. Learned Counsel for the respondent number 6
And 9.
9.
I'm also praying for 2 weeks' time within this, my lord. We will
Okay.
file it.
And what about the service? Other 6 to 9.
Completed. my lord. Everybody.
Or somebody 7. Some 7 is
7 already appeared. 5 and 7 already filed affidavit.
5 and 7 already.
Yes, 5 and 7 has filed their affidavit.
You represent 6 and
6 and 9.
9. What remains? 8.
8.
8 is served.
It's I guess. it is. Let it be after 2 weeks, but in the meantime, I will ensure. Otherwise, it is the IOCL whose stand would be more relevant.
No, it will remain in
Yes, that's.
order column only.
Yes, yes.
That is why I am
That
trying
is-
to find out. You want
I'll
to
have
it in the order column, will not observe anything.
No, well, I'll check up.
Please the
because
case on so and
There
so.
was a liberty given to us to serve Dusty also. I'll check that. In the meantime.
Both Mr. Buru and Mr. Lotto have sought for and are granted
2 weeks.
2 weeks time to file their respective counter affidavit. List the case on so and so.
18 September.
Apply.
Oblige.
Item 43.
Yes, Mr. Mohanto. D. Mohanto for the petitioner. Petitioners. N. Bodulai, Revenue 1. N. Goswami,
For
2 and 3. As per order dated 28/7/2026 of the Loajima Court, service of notice upon the respond number 4 is complete. First of, as all notices have been served upon all the respondents, list the case on so and so in the appropriate column. The respondents are granted time till next day to 0 to file their respective counter.
23rd September, 2309.
The interim order passed, the rest shall continue till the next day.
Item number 44.
May I please your lordship, lordship, in this matter, as per office note dated 28/7, it shows that service is complete upon respondent number 5.
Heard Miss
You
Even
have-
Ondal, learned counsel for the petitioner. And Mr. J. Henry. 1 to 4. Huh? Junior communication লিখি দিব। As per order dated 20/07/2026. Service of notice upon the respondent of 5 is complete. Search sheet has been submitted.
Yes, lordship, actually.
Huh? If FR is submitted, you have a right to receive the notice for acceptance of the FR. When you can file a protest petition, right? The magistrate either accept the FR or may not accept, right? While accept, if not accepts, he can direct trial. He can also direct further investigation. Or accepting the final report, he can also direct filing of complaint. Many options are there. Now, once a judicial order is passed, now Supreme Court has said no to 26. No to 26. Now, where have you stated? Where is the date? And where is the final form number?
Para was.
Get the,
Lordship, that FR, that.
you mentioned that completed investigation and submitted final report before the competent court, right? And matter is within the jurisdiction of learned magistrate to either accept or reject such report or direct further investigation in the case. You can avail all the report. Let us have the final form number and date. Then thereafter we'll close your writ petition. Right, so that you can obtain the final form and file the protest petition on seeking direct investigation. Hard, Miss Nanda. You get information, number and date. And Mr. J. Hendrik, who's an junior government advocate for the response number 124. Report of Kuluniki. As per order dated, so and so Kuluna, response number 5. Okay. Mr. Hendrik has submitted, on the basis of instructions received from the senior superintendent of police, Sribhumi, that after making investigation into Bazari Chera Police Station case number 209/2024, registered under sections 281/125 within bracket small b, Bharatiya Nyaya Honita 2023. The investigating officer of the case had already submitted a final report before the court of competent jurisdiction. Full stop. Mr. Hendrik has submitted that the details of the final report so submitted are not available with him today. Full stop. Mr. Hendrik shall obtain instruction as regards the details, shall obtain the details about submission of the final report on the next date of listing. List the case on so and so.
1609.
You take back this one.
Lordship.
Then we'll decide.
45.
Place the case on so and so in the appropriate column. Appropriate column.
May I please? My lord, in this case, a truck co-petitioner went missing. In the 19
What missing?
Truck, my lord.
Truck.
My lord, then he lodged an FIR and also intimated the insurance company, my lord. The insurance company, my lord, insisted that since the final report is not submitted, so they will not settle the claim until the so, my lord, earlier petition approached this honorable court directed the police to submit the final report. That was not done. This is second time. My lord. Now, in the meantime, my lord, they have submitted the final report.
Case is true.
Yes, it's true. Yes, ma'am.
And anybody has been charged with it?
No, my lord, actually.
Evidence is less. Okay.
Lordship, since the final report, they can submit it before the insurance company, and Lordship can fix a time frame within which they will decide the.
So you process his claim application as per law.
Yes, Lordship.
And decide, take your own decision.
Yes, Lordship.
Whether to accept or not to accept with a reason one. We can close.
Yes.
To accept and not accept, my lord.
No. You have made a claim.
My lord.
Insurance claim.
My lord.
It is pending.
My lord.
They are, according to you, delaying the matter because there was no final report.
My lord.
Now final report is there.
Yes, ma'am.
Right?
Yes, ma'am.
And you have brought it to the knowledge of the insurance
We have
company.
submitted, my lord.
Right?
Yes,
I think this is my understanding.
my lord.
Now the application is to be taken forward.
Yes, my lord.
Your claim application is to be taken forward.
Yes, my lord.
And to decide.
My lord.
And your submission is that it should be done as expeditiously as possible.
My lord,
And Ms. Mozumdar would say 3 months.
My lord.
No issue, Lordship. 3 months. Fine.
Yes, my lord.
Okay. Take up both the IA and repetition
My
together.
lord, my lord.
Third, Mr. J.C. Gore, learned counsel for the writ petitioner, this applicant. And Miss R.D. Mojumdar, learned counsel for the respondent number
4 and 5.
4, 5. Respondent 4, 5, then OP, opposite party number 4 and 5. Also heard Mr. J. Hendrick, learned junior government advocate appearing for the respondent number, respondent as opposite party number 1, 2, and 3. Full stop. Para. The writ petitioner has preferred the writ petition. On stating that writ petitioners, okay, petitioners, huh? And applicants. And the writ petitioners. So the writ petition number 1 is the widow of one late Mohindra Chandra Saha. And writ petition number 2 to 4 are sons of late Monindra Chandra Saha. Full stop. Who are the others?
Others are my daughters. Two daughters.
Okay, the writ petition number 5 and 6 are the daughters of late Monindra Chandra Saha. Full stop. Para. The writ petitions have preferred the present writ petition in the capacity of legal representatives of late Monindra Chandra Saha. Full stop. Para. It is the case of the petitioners that late during his lifetime, late Monindra Chandra Saha owned a vehicle within a truck bearing registration number AML-461, the subject vehicle for short. And it was stolen by miscreants. In 1992, in that connection, Monindra Chandra Saha lodged a first information report on 7/4/1992, right?
My lord.
And also lodged a claim with the respondent number 4 as the insured. Lodged an insurance claim with the respondent number 4 as the insured on the premise that at the time of theft of the subject vehicle, the subject vehicle was under a valid insurance policy. Where is your case? Post. You approached earlier. Why is that? The respondent number 4 had duly acknowledged the receipt of the insurance claim by registering it as claim number 3222300/5/MV/45/91-92 against policy number page 22 92/32230/5/0 on 21/4/1992 comma, the respondent number 4 sent a notice to Monindra Chandra Saha, within brackets, since the Monindra Chandra Saha, asking him to submit a number of documents, including the final police investigation report, comma, to consider and process the insurance claim. For of other details, it is noticed that Monindra Chandra or who he expired when?
Mununna sir expired.
When?
He expired.
Monindra Chandra Saha expired on
27/5/1997.
27/5/1997. So when even after +8 years of submission of the insurance claim and date of Monindra Chandra Saha, comma, the respondent, there's opposite 40 number 2, 4 and 5 did not bring the process in connection with the insurance claim to a finality. Comma, the present petitioners had approached this court by way of a writ petition, comma, WPC number 1762/2000. With a contention that the petitioner's claim for theft of the subject vehicle had not been entertained by the respondent insurance company for want of the final police report. Also, in the state writ petition, comma, a prayer was made for a direction to the concerned officer in charge of investigating officer to submit the final report before the Court of Land's Chief Judicial Magistrate, comma, Kokrajhar, in connection with case number, Azna, key case number? Ukhaingaon Police Station case number 54/1992. Post of. By an order dated 24/3/2023, the said writ petition was disposed of with a direction.
2003.
Oh, 2003. The said writ petition was disposed of with a direction to the state respondents, more particularly, specially, comma, including the officer in charge, Gukhaingaon Police Station, to take necessary steps for submission of the final report to enable the petitioners to place the claim before the respondent insurance company within a period of 3 months. Full stop. When even after long, even after lapse of more than a decade, no final report was in connection with so-and-so case number was seen to have been submitted, the petitioners have once again approached this court by the present writ petition seeking inter alia direction to the respondent authorities, more particularly the respondent number 3. To comply with the direction made in the order dated 24/3/2003, passed by this court in the writ petition WPC number 1762/2000. And or alternatively for a direction to the respondent number 4 and 5 to settle the claim of the petitioners without waiting for the final report in connection with case number so and so. Post op. During the pendency of the when the writ petition is pending, the petitioners came to learn that in connection with after completing investigation into so and so case number, the IO had already submitted a charge sheet,
Final report.
a final report. Final report. Final report number 20/2024 on 6/9/2024. Observing inter alia that even though the incident was true, the driver and the handyman of the subject vehicle were untraced. Post op. The interlocutory application ISC number 2465/2026 has been preferred to bring on record the subsequent fact of submission of the final report in connection with so and so case number. Post op. Para Mr. Gaur Learned counsel appearing for the writ petitioners that applicants have submitted that in view of submission of the after a copy of the final form has already been submitted to the respondent, respondent number
4-1.
4 and
4.
5.
Respondent opposite party number 4 and 5. When? On
On 10th January 25.
10
10/1/25.
2025. Post op. He has submitted that as the present writ proceedings is pending before this court, he has submitted that the pendency of these repetitions, present repetition is perhaps the reason for the respondent number
4 and
respondent as opposite party number 4 and 5 for not bringing the process of the insurance claim in relation to the subject vehicle to a finality. Post up. Ms. Mojumdar, learned counsel appearing for the respondents, this opposite party number 4 and 5 have submitted that since the final form has been submitted, is stated to have been submitted by the petitioners, the applicants, for in connection with their insurance claim, the processing of the the process of the insurance claim will be taken forward to bring it within a reasonable period of time. So according to Ms. Mojumdar, a period of 3 months will be sufficient to bring to process, to consider and process the insurance claim submitted in connection with the subject vehicle to a finality. First of, in view of the broad consensus arrived at, Mr. Gore has submitted that both the writ petition and the application, interlocutory application, submitted that a direction be made to the respondent number and opposite party number 4 and 5 to process, to consider and process the insurance claim to a finality as expeditiously as possible. Absolutely. In view of the broad consensus arrived at by the learned counsel for the parties in the aforesaid manner, both the writ petition and the interlocutory application are disposed of with a direction to the respondent number 4 and 5, respondent number 4 and 5, opposite party to take the insurance claim, submitted by late Monindra Chandra Saha during his lifetime and pursued by the present petitioners, in connection with the subject vehicle on board, and thereafter to consider and finalize the same as per law. The entire process, it is therefore, it is further directed that the entire process is to be completed within a period of 3 months from the date of submission of a certified copy of this order by the petitioners at the office of the respondent number 4.
4 and 5.
4 and 1 will do.
1 will do.
At
Because
the office of
I'll
the
be also submitting. So
respondent number 4.
4.
With the observations made and directions given above, the writ petition is disposed of. Writ
Highly
petition and the
obliged.
interlocutory application are disposed of.
Highly obliged. Lord.
There is no order as to cost. No, like, no cost.
Item 46.
May it please your lordship. As per office not dated 27/7/2026, notice sent by speed post.
You are Mr.
I'm for petition.
Name is
I.L. Ngamlai.
for the petitioner, Mrs. J. Henry. Vinay Government Board Assam for the respondent number
Respondent 1, 2, and
1, 2, and
4.
4 also. Executive officer. Municipal board.
Lord,
You were not there earlier.
Lordship, it only 1, 2, the 4, they send a one instruction to me, Lordship.
As per, in view of the office note dated 21/7/2026, let the case be placed before the Lord Jima Court for a report as regards service of notice upon the respondent number 3 and 4 First of all, list the matter on so and so with the report. The interim order passed I shall continue till the next date of listing.
25th September, 2509. Timing matter, item 4.
Mr. Yes, what is the instruction?
Lordship, I apologize for in the morning, Lordship. Lordship, I have received an instruction. They require the premises to be on the order of prohibition for some more time because the quantification of the goods that were lying there was not completed. They have given that the petitioner deals in bitumen, solid form and also in liquid form. And in the tankers that were attached to some machines, in that tankers, the bitumens were in liquid form and the solid forms were scattered all over the place. They couldn't quantify it. That's for that quantification has to be done so that they can.
But where is the power?
No, if Lordship looks at page 30, in the Panchnama, they have stated that the entry was peaceful. In page 30, under the heading inspection search conducted number 7, Lordship will see that the stocks goods available at wherever these were not examined. Those things that they have examined, they have tick marked it. Lordship.
When did you visit it?
30th of June, my lord.
27, Lordship.
27 was 30th of June, my lord. Search is
30th June.
June and 2nd of July it was concluded.
It's there, Lordship. Whatever instruction is there, and that I'm placing it.
Let him come to keep this premises closed Friday. Explain his source of power. This man, because where is the provision under section 67? Either you can keep this all the things in the jimma of somebody. If it is not possible for you, all this by preparing Panchnama, where is that? It is a prolonged time from 2nd July. We are in
August, end of August.
where is the right to take 45 days
Lordship,
to have the custody by closing the gate?
Lordship,
where is that traceable? Is it traceable?
No.
To some statutory provision. I am with you. If you have the statutory power, or if you have the power, show us. Then only we'll be able to understand. Otherwise, it looks like that your action is high-handed. Section 67. Who is the person?
Lordship.
Who is the person?
Respondent number, my lord, is 5.
It will be 5. Lordship,
Respondent number five.
intelligent.
Let us see who is he.
Superintendent of State Tax.
He is the superintendent of the GST intelligence and enforcement.
Superintendent of
Name is Superintendent of State Tax.
GST Intelligence and Enforcement.
GST Intelligence. Now let us see his authorization. It must be authorized, right?
Yes, my lord.
Yes, Lordship.
Page 19, my lord.
Page 19. One has been represented before me. I have reason to believe. Who is he?
Lordship, the top at the top, his name is written.
Huh?
He is Special Commissioner, my lord.
Okay.
And this is given by the
Special Commissioner of State Tax.
Yes.
Right.
Former.
He has reason to believe. I authorize and require you. Okay, Superintendent of State Tax under section 62. Okay. Where proper person not below the rank of junior. Proviso to subsection 2. You prepared Panchnama?
Yes, Lordship. This was.
Then what is the problem? Whatever is seized, you have prepared seizure list.
Yes, yes,
Huh?
yes, ma'am.
Page 20, man.
Page 20. So what is the issue of this counting?
No, because he's stating that his office is also inside that premises.
No,
Lordship.
that first proviso to subsection 2.
Yes, ma'am.
Then subsection 5. That is he is entitled. Then let us see the rules from 139 onwards.
Yes, ma'am.
Rule 139 or what?
139.
139, right?
Inspection, search, and seizure.
Just a minute. These rules and so very difficult. Code. How many rules? What is the order of seizure?
Page 20.
Based on GST. So requirement is to pass an order of prohibition.
That has been passed, madam.
That has also been passed.
Yes, madam.
So in
Page
GST
27.
INS 03.
Yes, page 27.
As per
Rule 1.
annexer INS 02. 02 means
Seizure order, ma'am.
seizure order.
Page 20.
That is page
20, ma'am.
20. So many vehicles, all these.
The third party vehicle is a part.
Yes, ma'am.
Strategy.
Panchnama. Sub-rule 4. So where is the provision for 45 days, say?
Provision, Lordship, only that till notice is of 6 months, Lordship.
Huh?
That is there.
No, where is that?
Lordship, section 67, subsection 7.
67.
Subsection 7.
This is regarding notice.
Notice, Lordship.
And keeping the seized material in possession. Right.
Particularly, Lordship, if it is in our possession. But since
No, that if you give by,
we can entrust him.
if you give by that INS
Entrustment.
03, it means it is your possession.
Yes, Lordship.
Right. If he does anything with it, he will be liable. He is at more risk after give him the Jima. If you give him the Jima by INS 03, he will be at more risk. One, the search proceeding. Whatever would happen, we don't know. But after he given Jima, he eats it or consumes it, or the vehicle, he takes it outside. He will be liable for the entire value of the vehicle. Right. He is at more risk. But question is about
Prohibiting from entering.
prohibiting is also there.
Not
Prohibition is not to part with the
goods.
seized goods. Now sealing is another 67(4). Right?
When there is no order for sealing also, Lordship will see the order of prohibition, does not speak for sealing the premises. Only they pasted a paper mine.
What he is besieging the power or what? What is your instruction? Now, today is not possible for me
Lordship
also.
can,
I have some constraint, otherwise let us have it. I have some constraint up to
My lord, is judgment of court
Friday.
bench, my lord.
Yes, yes.
Will
Please
have
give it to, give it to. Already ready, you file it by Friday?
Yes,
We,
Lordship.
we put it on Monday or Tuesday? Monday khali ase to ama.
Tuesday is holiday, my lord. Monday.
Huh?
Tuesday perhaps holiday. Monday.
Monday?
Monday, yes.
Monday.
Monday.
You file it by almost ready. I'll not look into it.
Yes.
Mr. Maestro will point out. Right. I had Mr. Mistro, R.S. Mistro for the petitioner. And Mr. B. Chaudhary, and Standing Council Finance and Tax number ase ha? Aru R. Sharma number ase. Mr. Chaudhary has submitted that he has already he is in a position to file the affidavit in opposition on behalf of the respondent number.
It will be 5, Lordship.
5. By Friday. Close up. In view of the same, let the case be listed on Monday. Oh, there is meeting, I am told.
Item 5 is there, no item Monday.
These are Monday,
Fine.
47,
Fine. Item 5.
48 and 49, and also
5.
5 Monday. That day I'll sit longer.